Hello, good morning. We'll see if this is actually working. Sorry, I'm still like setting up things and making sure things are correct. Ah, you would think that I do this almost every day, that I know what I'm doing. Please let me know if you can hear me, because I don't want to be talking to myself again and people thinking that I'm weird. But welcome in, everyone. Good morning, Paula. Good morning, Denise. Very nice to see you both here, as always, and everyone else that will come in later if there is, but if they don't, um, and it's absolutely fine, Paula. It's yeah. Um, I tried the talk to texting on the other day, and yeah, I don't think I'm gonna use that again. Um, so because it made so many typos that I had to correct the typos. So, but it's fine. Don't worry about the typos. It's all good. Um, so today we have the closing arguments on this trial. It's exciting. It's been seven. Today is the eighth day, 7 days trial. Um, in my opinion, right from yesterday, the case that the defense put on, and let me know if you disagree. In the chat, it's absolutely fine. Different opinions are always welcome, but I thought that the defense case, there was just the father, the brother, and I think that was it. It was more of a character reference. um Awesome. Was a character reference for Sheldon, um, Timothy, the Herrington guy, the defendant in a case. So I don't think they put much because, to be fair, there is a lot in my mind as well, a lot of doubt, because I know with nobody it's hard. All the evidence that they have is circumstantial, like where Ole Miss was, and it's okay, Paulo. I can try to do like a little bit of a recap of this trial, but to be fair, you have a mismatch. So this trial, it's a little bit hard because it's a big, massive, touchy subject. Um, yeah, what case exactly? Because it's like they put what, two witnesses, three witnesses tops yesterday, and then that was it. But to be fair, I don't think they really need to, because I don't think they have that much of a case. Because like there is no body, there is no actual 100% proof that the the crime actually happened, because there is no body, and they cannot prove. Well, yeah, a judge had to declare Olimis dead to be able to be charged with capital murder, but still, it's a little bit hard to prove, because everything else, like the um footage that they shown, the security cameras, the card thing that there was witness talking about getting into the apartment or not at the university. It's all really circumstantial, in my opinion. Let me know if you think about something else, but it's absolutely fine if you don't. um so I don't know if he's charged with any other charge, because we missed the part of the charges from the judge in the beginning of the trial, because the feed only started halfway through the openings of the openings of the prosecution in this case, which, in my opinion, the prosecution has been doing very well this case. I really like that the African American lady, I don't know her name, don't ask me the names of them, I don't know. I tried to get information on this case. Mississippi, it's a very hard state to get any information out of. I don't know why they are, but it's a little bit hard. But anyway, carry on my train of thought before I lose it, because I am gonna lose it for sure. Um, what was I saying? Saying I already lost it. I was saying that the we don't know what other lesser charges is charged on, because I don't think capital murder actually is applying here. Maybe second degree, yeah, manslaughter is probably a little bit of a stretch. Um, but either second degree, if that actually exists, or I don't know what I'm talking about, but um, either that or but I don't think capital murder. It's that yeah, because I was gonna say this capital murder in Mississippi has the, well, first of all, as Mississippi has the death penalty, because I don't even know. Um, let me uh see if there is the, oh, okay, they do have um death penalty still legal in Mississippi. So basically this trial technically cannot be finished today, because if it is capital murder can be the death penalty, isn't it? Oh, it's just so um yeah. Oh no, now I see why he got charged. Uh hmm, right. But see, this is, yeah, he can't be free facing death. So if we get a guilty verdict on this on this case, then we're gonna go into this as sentencing phase, the death penalty phase, which is gonna make things more complicated. Because me here thinking that tomorrow we're gonna do the Chloe Driver sentencing, and then I was gonna have an easy day tomorrow, but apparently not, because if he does get a guilty verdict tomorrow, then if he gets convicted on the capital murder charge, but if it is any lesser included, it should be finished by now. Um, yeah. Oh yeah, because this is but wait, was Carly Gregg? Because Carly Gregg was also Mississippi. Was Carly Gregg as well capital murder? Because always just, yeah, then it was not capital, because sorry, I'm just thinking out loud and I'm talking while I'm thinking, because she got the sentence to life in prison without a possibility of parole, and that, so that must be just, sorry to say, normal unaliving, normal murder, and not a capital one. Be- yeah. Oh wow. It's really interesting. So he is facing death penalty, but I have not heard anyone mentioning that. This is the thing, not knowing what charges he's facing, because I can hear is like I hear people saying capital murder and normal murder is two different charge, but he is charged. He got indicted on a capital murder. So, and by what Google says, in Mississippi, it can be a death thing. Yeah, because accordingly a defendant convicted of capital murder may be sentenced to one, to death, two, to life imprisonment without parole, or three, to life imprisonment with opportunity of parole. This is interesting. But now, more important, how long do you think Denise or and Paul, if he's still here, is do you think that they're gonna deliberate on this case? I don't think they're gonna be more than, I would say, 3 hours. I I'm not saying, because of the evidence that we had, even though that we did not go through the Sunday properly one. Oh yeah, that is true. She probably, yeah. Oh yeah. I keep forgetting Carly was still is what, 14, 15, and a bit, yeah, youngish. Um True, she might have not faced because of that, but he's also young as well. Like not as young as Carly. I don't think we're gonna have, well, I think we're gonna have another one, because there's another case popping up of a youngster. What is all going on with youngsters and then unaliving? It's keeping us busy, sadly. Um, why this court today keeps moving the feet? I don't know. Um, so I find, sorry, I find having me in the background of the headphones. If I like hearing my own voice, I get distracted. So it's like ADHD. Like, well, I don't think I have ADHD. I just self-diagnose. I get distracted, but I think my other half does. Um, so even though Paula, you haven't really been on stream, sadly, and understandably, what's your opinion on terms of deliberation? An hour, 2 hours? It's a capital murder case. Been 7 days now that we've been on trial. Day eight is today, but today is going to be the closings and verdict watch. There is no jury instructions to do because apparently they did them all yesterday. And I'm kind of glad that I did finish the stream yesterday when I did, because and I could have ended earlier if I would have paid 100% attention to what they were saying. I am paying attention, but sometimes just information, because I'm watching two trials, and there's a third one that I want to watch, but I don't know if I'm going to be watching that one, um, or covering that one on here. Uh, but yeah, I was a little bit distracted, and there was the hearings as well yesterday. I was trying to catch up on, the jumper, the Las Vegas jumper. He got sentenced yesterday. I think RA missed that one. The sentence of that guy is, he blabbed for so long. It was like, a Sarah Boone, Melody Ferris type of blabbing, which was amazing. I'll try to find it, and maybe while the jury deliberates, we can have a look and we can listen to it. Um, yeah, it's all right. Don't worry, Paula. It's okay. Sorry to put you on blast. Oh, I heard noises. But like I was saying, probably during verdict watch, we're gonna watch the Las Vegas guy um sentencing, this rumble. Um, he felt like he spoke. Oh, it's about an hour, the sentencing, so probably we're gonna have enough time to watch the whole thing. We can watch it while on verdict watch. The sentencing, it's just like, something for you guys to watch. And I tried to watch, but I kept falling asleep last night. I'm so tired after work lately that I just want to sleep in the afternoons. And then I made the mistake of going to bed and stream, being looking at the stream and listening to court while I was in bed, not streaming from bed, because you guys cannot see me, and that would be a little bit weird to say. um but yeah, I was trying to watch them. I kept falling asleep. I think I had about, what, 5 naps yesterday, which was yeah, quite a few naps, and then I still slept during the night. It's like, I've been there because it's a new department that I've been working on, and it's also, I've been starting at 4 o'clock in the morning in my time, so I have to get up about 3:15, because now I only work. I take 4 minutes. 4 minutes to get home and to get to work, um, which is good to take that less time. But it's so little time. I don't even have enough time for my phone to connect to the car so I can listen to music. So I've been listening to the radio, and radio now only plays Christmas music. And nothing against Christmas music, but sometimes it's just the same music all over again, and it just gets a little bit confusing. um but yeah, we're just waiting on court to start. Court should be starting in about 3 minutes, and then I'll be quiet for the rest of court. And again, during verdict watch, we'll be watching the Las Vegas guy sentencing. It's about an hour that it took. And his rambling was amazing. um Hopefully, because, yeah. Oh, there's a better video there. That's awesome. That's gonna be good, instead of using the other feed. Let me actually have that up. I'll pause that one and restart this one, so then we can watch together. But that's something we can do while on verdict watch. And then I don't think we're gonna have much longer, because I don't think they're gonna be taking long time and deliberating, in my opinion. But we'll see what happens. But yeah, so tomorrow the plan is, if this is actually a death penalty case, what we're going to be doing is, um we'll carry on covering, obviously, but first of all, in the morning, we're going to be doing the Chloe Driver sentencing, and then we'll catch up on this case. We'll always come back if it is actually death penalty case. I'm not 100% sure. It does look like it, but no one has mentioned anything, because we missed the charges from the judge again in the beginning of the trial. But we'll see what happens. I guess we're here for the fun of it, and um I just wish the court would start, because I'm running out of things to say. I don't know, but I mean, so yeah, so that's what we're gonna do tomorrow. I know I've already put the stream for the sentencing for Chloe sentencing on, but I've already have another thumbnail that I can swap if this case does carry on. I just wanted to do it the setup of the live stream so I don't forget to do it. And tomorrow when I get back, get in from work, I don't have that much to do, because I have because I'm helping out people in the Discord in as the gavel drops people. Been trying to help with the document with the cases, because there's a lot of cases. And I have my own cases that I've been following, so I have quite a few hearings today that I need to keep my eye out for, and then tomorrow I need to post about them or change and do some work on that. So I'm going to be trying to save a little bit times, just thinking ahead. But yeah, I mean, there's not much more going on. Uh yeah, it's almost the weekend. It's 2 days to the week, and I can't wait to slip in a bit during the weekend. 2 weeks until Christmas and 3 weeks until the new year. Wow. 2025. I hope that's the year that I get to work from home and not having to go outside and put up with people. Because sometimes people are not, yeah, it's people. Um, but yeah, I don't know really what else to say. The court should have been here by now. Let me out actually, because I think I paused the stream early. I know it is. It is because I what I was thinking was that I was doing something that the feed for the court stopped, and I thought that I didn't have to press to play again, and the court already had started without us, and that cannot be. Court cannot start without us. We have to be present there. But so yeah, so I'm gonna talk about the weather like a good English person does, even though I'm not English. The weather here in UK actually have been right a mile. I mean, if you guys have any questions or if you want to talk about something else, just let me know. But I can carry on talking about the weather. I mean, I think the weather everywhere is miserable at the moment. It's the winter, but trying to talk about something positive. Oh, I wanted to talk because I did say this on the Facebook group chat. The CEO and live, I think the Luigi Mantioni guy. Um, I don't think he really wants to be extradited to New York, and my opinion is because New York doesn't transmit any courts, doesn't live stream any courts, and he probably knows that. He's a very smart dude. So he probably knows that they don't live stream courts. So he doesn't want to because he wants the attention of all the media. He's still gonna have attention from the media in New York, that is for sure. But he doesn't want to because he wants to have his saying, because I'm sure he's going to be pleading not guilty no matter what, even though it's like, the sheriff in Kentucky, that there is more evidence that he did unalive the judge, and there's that, but he still pled the not guilty to be able to go into trial to say his part, to say exactly what happened and all the information that has been coming out about the judge. So I think he's going to be doing the same thing, but he wants to do that. Um, he wants to do that because he wants the attention, and the saying is part of what happened about the CEO and everything else. That's my opinion, because I don't think he wants to go to New York. But if he did end up going, I was gonna be interesting. Is he gonna be put with P Diddy? Can you imagine those two together in the same cell? That would be interesting. Um, but yeah, I was like, it's a bit, obviously unaliving someone is never right. That's not never the way to go to find the means. But he might have had a big motive, like the guy in Kentucky did. Because there's stuff coming out about the judge in Kentucky that's coming out. They are not pretty at all. So that's going to be an interesting case for, well, I don't think it's going to be next year, but we'll see. Because I think next year there's already a lot of big cases. I think next year is definitely going to be a very, very busy day in big, and big for true crime. I mean, we have Idaho 4, we've got Lori Vallow, pro se. Sorry, I can't say that with a straight face. Lori Vallow, pro se. It's gonna be hilarious. It's gonna be amazing. Like Sarah Boone, who? It's literally gonna be everything about Lori Vallow next year. And then I think we have the Steins guy as well, the Madeline Soto case. The two trials of his are next year as well. Um, we have the Peak County massacre trial as well going on for next year. Um, there's already big four ones. Donna Adelson, I think it's also going to be next year. So five big cases next year. So yeah, it's gonna be a 2025. It's looking promising in terms. Sorry, that it's not great to say. It's looking promising for unaliving trials, but it there is a lot of big cases next year. I mean, just the Idaho 4. That's gonna be a big con. I think it's summer, isn't it? Yeah, summertime. It's gonna be 4 months of the same trials, like a YSL version, but less. First of all, I think the jury selection for that one is going to take forever. It's going to be very, very hard to find uh jurors in that local area that haven't heard um about this case. Yeah, and then there's a lot of smaller cases, but this ones are the massive headlines. But I don't think Steins or this one, the CEO, unless they do not waive the speedy trial, there's going to be a lot of good cases. Ooh, okay. No, Denise, that's going to be awesome. I don't think I'm covering that trial. First of all, everyone is going to be covering. RA is the one that I really want to watch for, the trial on. I will be streaming smaller trials. Whatever other people don't stream, I'll stream those. I'll be the because everyone is going to be streaming Idaho 4. It's going to be the BK. So oh, that's nice. Thank you, Paula. That's very, very nice for you to say. I was just like, I miss talking on stream and interact a little bit more, but sometimes it's a bit harder because like during the day it's harder, like during the day, during the lunch breaks and everything. It's a bit harder for me to do it because it's like my dinner time and then it's almost my bedtime. I still want to do this, and my husband has been amazing because this trial has been running into late, and I just got back to work, and he's been the one like doing the shut off of the stream and turning off and fixing issues if there is while I'm already sleeping, because like I said, I have to wake up at 3 a.m. around 3 a.m. to go to work for 4 at the moment. I am going to be starting again in the new year in January, only starting at 5 a.m. So I'm going to have another hour. And also, I jumped on this trial without even thinking where Mississippi was. I just saw it. Oh, a new trial. Let's go. I did not really investigate anything what was about or even the state, because I say and I'll always say I will always try to cover trials. There is like Georgia, Florida, New York, in that, like Vermont, like those states that the time difference is not a big time difference for me. It's only like 5 hours, so I can still like managing to be present for the whole stream and not having to um always rely on my husband. He's a great person. He's a great guy. He does it, and I know he complained, but he does it in the end. You know, every man complains about when we ask them for something, but I don't want to give him that burden anyway, and I want to be interacting with everyone and talking to you guys. So yeah, but I just jump on thinking Mississippi was the same time zone, but no, I'm still learning my time zones. Don't I like? Yeah, maybe when I'm off, like I have a week off. I think it's at the end of January, and if there's not like we already not on trial, um, I can try to cover a trial from another state. But that's the thing; it has to be a week long trial, because then obviously it carries on, and I when I'm back at work, it will be harder. But there's also we have a busy week next week. So on Monday, just talking while court hasn't started. That's just they're never late. Sorry, just checking that the stream is still correct, still not unpaused, just to make sure that we are on time. Let me actually double check another feed, because there is another um feed, another news covering this trial. It says it's, yeah, no, they still don't have a feed either, so that's fine. It's not the yeah, because yeah, I thought they're a bit late, because the judge did say 8:30 their time, which it was about 10 minutes ago already. um anyway, I was saying the next week we have a peak, the hearing, the peak, what's it called, the peak, where's my calendar, big county hearing for the massacre again next week on Monday. If we're not on trial, we cover it. Otherwise, we'll probably cover like at lunchtime or something. And then also next Thursday on the 19th, we have the Ronda Jewel sentencing um as well, also from Florida. She is the one that left the baby in the car for 5 hours, and that she forgot about it. So her sentencing is coming next week. That's going to be another hard sentencing. Tomorrow, the Chloe driver. I don't think, would it be interesting? I don't know. I don't think Binian Ben Michael, or I think that's his name, is gonna be talking. I don't know if there's actually anyone gonna, maybe her mom is gonna talk on her behalf. So we'll see what happens. So she was found guilty by mental illness. I need to do some investigation on what is the possible sentencing for that. So in Georgia, so guilty by reason of mentally ill, Georgia. See if uh it's gonna be a term in prison, but I don't think it's a whole life. So I don't think she's gonna be, because automatically in Georgia, and we've learned that from Melody Ferris case, that in Georgia it's an automatic life sentence for unaliving. But Chloe is different, because she was an unaliving mentally ill, so that's a little bit different. So I think she's gonna get like a number of years sentence, and hopefully while she's in prison she will get some treatment for her mentally illness. So yeah, so probably it's, oh, let's see, there's the Georgia code. Let's try to read this while I talk and before court starts. Um, I don't think I can, but it's just talking about the case laws, and then whether insanity at the time of the offense was temporarily or permanent. But that would be to see if that was suitable. So my Grimes sanity, yeah, to see if she was stand trial. That's not after um found guilty. So let's scroll down. Then the application evidence, the solution of spouse. No, that's not applicable to this case, I don't think. Defendant's testimony of lack memory following the blow to the head, but the verdict of guilty but mentally ill proper. So testimony from the defendant's expert that the defendant suffered from a major depressive disorder, Asperger's disorder, and schizophrenic personality disorder, had a major capacity, right and wrong was delusional, and from a point of court expert that the defendant knew right from wrong and was not suffering from any delusion, compulsion. That's way too many big words that I did not buy today. So no, it doesn't say the but that's talking about the burden of proof. That's what I was thinking, to a state hospital, Paula, but I don't know, because all that I saw, the when she was found guilty but mentally ill, it was that she would go to prison, and hopefully in prison she would get treatment. But now all of this that it's talking about is, yeah, I think it's just how someone would prove the the case of guilty but mentally ill. But I don't know, maybe I need to do some more research than actually doing some research at the last minute on stream with you guys here, just trying to read with my eyes. And yeah. Oh, that section, where's I wish you could just go to a section on a website, but no, you have to scroll forever until you find exactly where you were, because there was something that sounds that is exactly what we are looking for, in terms of the sentencing that she is, that's talks facing. Okay, effect of guilt by mental. Okay, as a sorry, I'm just reading very quickly what does it say, this paragraph, because it talks about exactly what happened with Chloe. Your form to just okay, so it's just talking about how the jury should not let impact, and how this impact the yeah, but what is the real possibility of she getting help in prison? I mean, the system is already overloaded as it is. How would it's really the possibility of her getting any proper help? Um, so it's just very very hard to get.
Seated, everyone, and thanks everyone for being here. Is everybody ready to proceed? All right, then show the jury in. We agreed on 45 minutes. Anybody want any 2-minute warnings? Half and half, 2-minute warning. Okay, I'll give you that. You got it. Good morning. You know, nothing personal. Y'all seem like really good people, but I hope today's the last time I tell y'all good morning. Yesterday, I trust no one had any problem with court instructions not to discuss the case, not allow anyone to discuss the case with you, not form or express an opinion, investigate the case in any manner. If you had any problems in the trial of the case in that regard, speaking now forever hold the peace. I trust you have it. Yesterday, when we were breaking yesterday afternoon, I let you go early because I knew we had to get jury instructions together. I debated on whether just keep y'all a while and see if we could get those done quickly and let y'all start the deliberations yesterday evening. But about 9:30 last night, when we were finally leaving the courthouse, I think I made the right decision to let y'all go home. But we have worked hard getting these together. We apologize for the delay to you, but as I said before, this is important. We want to get it right. And I appreciate y'all's patience with us. This morning, I am going to read you the jury instructions. You will then have closing arguments by the attorneys. Like statements that matters about burden of proof will go first. The defense will then have its closing argument, and then the state will have its closing. On the record, other than the objections previously stated yesterday when we were having our jury conferences, are there any objections to the instructions given? Any additional objections? All right, here we go. Pay attention. I will say this. It's going to take a little while to read, bear reading, but you'll also be given written copies of these jury instructions, but still pay attention. All right. Members of the jury, you have heard the testimony and received the evidence introduced in the course of this trial. The court will presently instruct you as to the rules of law which you will use and apply to the evidence in reaching your verdict. When you took your place in the jury boxes, you made an oath that you would follow and apply these rules of law to the evidence in reaching your verdict in this case. It is therefore your duty as jurors to follow the law which I shall now state to you. On the other hand, it is your exclusive province to determine the facts in this case and to consider and weigh the evidence for that purpose. The authority thus vested in you is not an arbitrary power, but must be exercised with sincere judgment, sound discretion, and in accordance with the rules of law stated to you by the court. Both the state of Mississippi and the defendant have a right to expect that you will conscientiously consider and weigh the evidence and apply the law of the case, that you will reach a just verdict regardless of what consequences of such verdict may be. It is your duty to determine the facts and determine them from the evidence produced in open court. You should not be influenced by bias, sympathy, or prejudice. Your verdict should be based on the evidence and not upon speculation, guesswork, or conjecture. You are the sole judges of the facts in this case. Your exclusive province is to determine what weight and what credibility will be assigned to testimony and supporting evidence of each witness. You are required and expected to use your good common sense and sound honest judgment in considering and weighing the testimony of each witness who has testified. Although you, as jurors, are the sole judges of fact, you are duty-bound to apply the law as stated in these instructions to the facts as you find them from the evidence before you. You are not to single out one instruction alone as stating the law, but you must consider these instructions as a whole. Neither are you to be concerned with the wisdom of any rule of law, regardless of an opinion you may have as to what the law ought to be. It would be a violation of your sworn duty to base your verdict upon any other view of the law than that given. Arguments, statements, and remarks of counsel are intended to help you understand the evidence and apply the law, but are not evidence. Any arguments, statements, and remark having no basis in the evidence should be disregarded by you. The evidence which you are to consider consists of the testimony of the witnesses and the exhibits offered and received. Production of this evidence courts is governed by rules of law. From time to time during the trial, it has been my duty as judge to rule on the admissibility of evidence. You must not concern yourself with the reasons for the court's ruling, since they are controlled and governed by rules of law. You should not infer from any rulings by the court on these motions or objections to the evidence that this court has any opinion on the merits favoring one side or another. You should not speculate as to possible answers to questions which the court did not require to be answered. Further, you should not draw any inferences from the content of those questions. You would disregard all evidence that was excluded by the court from consideration in the course of the trial. You are not bound by any rules of parliamentary procedure in your organization or in your deliberation, but the court suggests that you choose a person to speak for you. You may vote on your individual's belief either by show of hands, secret ballot, or any other method you choose. If in stating the law to you, I repeat any rule, direction, or idea, or if I state the same rule in a different way, no emphasis is intended, and you must not draw any inferences therefrom. The form of the verdict is suggested in another written instruction or instruction. Your verdict may be in one of the suggested forms, and it should be written in the handwriting or printing of one of the individual jurors on a separate sheet of paper furnished to you for that purpose. None of the individual jurors has to sign your verdict. The order in which these instructions are given to you and the manner in which the instructions and exhibits are numbered has absolutely no significance. You will have with you in the jury room all the papers and evidence applicable to this case. Although during the trial other papers, documents, exhibits, or charts may have been mentioned to you, once you have entered the jury room for deliberation, no other documents, papers, exhibits, or charts may be given to you. Transcripts of the trial testimonies or parts of the trial testimony are not available. When you enter the jury room for deliberation, the court suggests to you that you discuss the facts of the case and review these written instructions before you begin voting or attempting to decide the case. The burden of proving the defendant guilty of every material element of the crime with which the defendant is charged is upon the state of Mississippi. The law makes no distinction between direct and circumstantial evidence. It requires that before you return a verdict of guilty, the state of Mississippi must prove beyond a reasonable doubt that the defendant is guilty from all the evidence in the case. The law presumes every person charged with the commission of a crime to be innocent. This presumption places upon the state of Mississippi the burden of proving the defendant guilty beyond a reasonable doubt. The presumption of innocence attends the defendant throughout the trial and prevails at its close unless overcome by evidence which satisfies the jury of his guilt beyond a reasonable doubt. The defendant is not required to prove his innocence or to offer any evidence at all. The verdict of the jury must represent the considered judgment of each juror. In order to return a verdict, it will be necessary that each juror agree thereto. In other words, all 12 of you must agree on a verdict in this case. It is your duty as jurors to consult with one another and to deliberate in view of reaching an agreement. If you can do so without violence to your individual judgment, if each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your views and change your opinion if convinced that your previous opinion was erroneous, but do not surrender your honest convictions as to the weight of evidence or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of reaching a verdict. Upon retiring to the jury room, you will select one from among your number to act as a foreperson. The foreperson will preside over your deliberations and will be your spokesperson before the court. If it becomes necessary during your deliberations to communicate with the court, you may send a note by the bailiff. During deliberations, no member of the jury should ever attempt to communicate with the court by any means other than a writing, and the court will never communicate with any member of the jury on any subject touching the merits of the case, otherwise in writing or orally here in open court. Bear in mind also that you are never to reveal to any person, not even me, how the jury stands, numerically or otherwise, until you have reached a verdict, unless asked by me in open court. The defendant has a constitutional right not to testify on his own behalf in this case. You are not to make any conclusions or inferences of guilt about the defendant as a result of the defendant exercising his right not to testify on his own behalf. You will not consider in any way during your deliberations the defendant's decision not to testify. Each person testifying under oath is a witness. You have the duty to determine the believability of the witness. In performing this duty, you must consider each witness's intelligence, the witness's ability to observe and accurately remember, the witness's sincerity, and the witness's demeanor while testifying. You must consider also the extent to which the witness is either supported or contradicted by other evidence, the relationship the witness may have with either side, and how the witness might be affected by the verdict. You must consider any evidence of the witness character. You must consider any evidence of the witness's character for truthfulness. In weighing a discrepancy by a witness or between witnesses, you should consider whether it resulted from an innocent state or a deliberate falsehood, and whether it pertains to a matter of importance or an unimportant detail. You may reject or accept all or any part of a witness's testimony, and you may reject part and accept other parts of a witness's testimony. After making your own judgment, you will give the testimony of each witness the credibility, if any, as you may think it deserves. The weight of the evidence is not necessarily determined by the number of witnesses testifying as to the existence or non-existence of any fact. You may find that the testimony of a smaller number of witnesses as to any fact is more credible than the testimony of a larger number of witnesses to the contrary. Any fact in this case may be proved by either direct or circumstantial or evidence or both. Direct evidence is direct proof of the fact, such as testimony by a witness about what the witness personally saw, heard, or did. Direct evidence is a testimony of someone who claims to have actual knowledge of a fact. Direct evidence is simply evidence which, if you believe, it directly proves a fact. An example is a witness testified that he saw it raining outside and you believed him. That would be direct evidence that it is raining. Circumstantial evidence is proof of fact or facts from which you could conclude by your reason and common sense that another fact exists, even though it has not been proven directly. Circumstantial evidence is proof of one or more facts from which you could find another fact. Circumstantial evidence is simply a chain of circumstances that indirectly proves a fact. An example is if someone walked into the courtroom wearing a raincoat covered with drops of water and carrying a wet umbrella, that would be circumstantial evidence which you could conclude that it was raining. The law makes no distinction between the weight to be given to either direct or circumstantial evidence. You as a jury should decide how much weight to give to any evidence. Deliberate design means an intent to kill without authority of law and not being legally justifiable or legally excusable. Deliberate always indicates full awareness of what one is doing and generally implies careful and unhurried consideration of the consequences. Design means to calculate, plan, or contemplate. Deliberate design to kill a person may be formed very quickly and perhaps only a moment before the act of killing the person. However, deliberate design cannot be formed at the very moment of the fatal act. The court instructs the jury that a killing occurring while engaged in the commission of a kidnapping includes the action of the defendant leading up to the kidnapping, the action of the kidnapping, and the aftermath of the kidnapping. The court instructs the jury that inveigle means to lure or entice through deceit or insincerity. Inveigling has no component of force, but only coaxing. Acting with a depraved heart is when a person acts in a highly dangerous way, which shows that the person does not care for the safety of human life. Even if someone does not intend to kill any particular person, he can still be guilty of murder if he acts with a depraved heart and a person is killed as a result. Culpable negligence is negligence of a degree so gross as to be tantamount to a wanton disregard of or utter indifference to the safety of human life. Negligence is doing something that a reasonable, careful person would not do under similar circumstances, or failing to do something that a reasonable, careful person would do under similar circumstances. Second-degree murder and culpable negligence manslaughter are distinguishable simply by the degree of mental state of culpability. In short, second-degree murder involves a higher risk of recklessness from which malice may be implied. The defendant, Sheldon Timothy Herrington Jr., is charged with the offense of capital murder. If you find from the evidence in this case beyond a reasonable doubt that Sheldon Timothy Herrington Jr., on or about July 8, 2022, in Lafayette County, Mississippi, did unlawfully and feloniously without authority of law and with or without any design to effect death, killed Jimmie Dale J. Lee III, a human being, while Sheldon Timothy Herrington Jr. was engaged in the commission of the crime of kidnapping by, with or without intent to secretly confine, inveigling Jimmie Dale J. Lee III with the intent to cause Jimmie Dale J. Lee III to be confined against his will, then you should find that Sheldon Timothy Herrington Jr. guilty of capital murder. If you fail to find the defendant, Sheldon Timothy Herrington Jr. guilty of capital murder, then you shall continue your deliberation to consider the crime of first-degree murder. If you find from the evidence in this case beyond a reasonable doubt that Sheldon Timothy Herrington Jr., on or about July 8, 2022, in Lafayette County, Mississippi, did willfully, unlawfully, and with deliberate design to effect the death of Jimmie Dale J. Lee III, killed Jimmie Dale J. Lee III, a human being, then you shall find Sheldon Timothy Herrington Jr. guilty of first-degree murder. If you fail to find the defendant Sheldon Timothy Herrington Jr. guilty of first-degree murder, then you shall continue your deliberation to consider the crime of second-degree murder. If you find from the evidence in this case beyond a reasonable doubt that Sheldon Timothy Herrington Jr., on or about July 8, 2022, in Lafayette County, Mississippi, did willfully, unlawfully, and feloniously kill Jimmie Dale J. Lee III, a human being, without premeditated design to effect the death of Jimmie Dale J. Lee III, while engaged in the commission of an act eminently dangerous to others and evincing a depraved heart, regardless of human life, then you shall find Sheldon Timothy Herrington Jr. guilty of second-degree murder. If you fail to find the defendant Sheldon Timothy Herrington Jr. guilty of second-degree murder, then you shall continue your deliberations to consider the crime of manslaughter, culpable negligence. If you find from the evidence in this case beyond a reasonable doubt that Sheldon Timothy Herrington Jr., on or about July 8, 2022, in Lafayette County, Mississippi, unlawfully and feloniously killed Jimmie Dale J. Lee III, a human being, with culpable negligence by engaged in dangerous sexual activity with Jimmie Dale J. Lee III, then you shall find Sheldon Timothy Herrington guilty of manslaughter, culpable negligence. If the state has failed to prove any of the above listed elements beyond a reasonable doubt, then you shall find the defendant not guilty of capital murder, first-degree murder, second-degree murder, and manslaughter, culpable negligence. The court instructs you that all 12 of you must reach and agree upon a verdict. If the court instructs the jury that if all 12 of you reach and agree upon a verdict, you shall return the verdict to the court in one of the following forms. If you find Sheldon Timothy Herrington Jr. guilty of capital murder, the form of your verdict shall be as follows. We, the jury, find the defendant Sheldon Timothy Herrington Jr. Sheldon Timothy Herrington guilty of capital murder. If you do not find the defendant guilty of capital murder, then you shall continue your deliberations, consider the lesser charge of first-degree murder. If you find Sheldon Timothy Herrington Jr. guilty of first-degree murder, the form of your verdict shall be as follows. We, the jury, find the defendant Sheldon Timothy Herrington Jr. guilty of first-degree murder. If you do not find Sheldon Timothy Herrington Jr. guilty of first-degree murder, then you shall continue in your deliberation and consider the lesser charge of second-degree murder. If you find Sheldon Timothy Herrington Jr. guilty of second-degree murder, the form of your verdict shall be as follows. We, the jury, find the defendant Sheldon Timothy Herrington Jr. guilty of second-degree murder. If you do not find Sheldon Timothy Herrington Jr. guilty of second-degree murder, then you shall continue in your deliberations and consider the lesser charge of manslaughter culpable negligence. If you find Sheldon Timothy Herrington Jr. guilty of manslaughter culpable negligence, the form of your verdict shall be: we, the jury, find the defendant Sheldon Timothy Herrington Jr. guilty of manslaughter culpable negligence. If you do not find Sheldon Timothy Herrington Jr. guilty of manslaughter culpable negligence, then the form of your verdict shall be as follows: we, the jury, find the defendant Sheldon Timothy Herrington Jr. not guilty. Your verdict must be in one of the forms written above. You should write your verdict on a separate sheet of paper. It does not need to be signed. Did the court read the instructions that were okay? Did the court read the correct jury instructions that have been decided by the parties?
Yes.
From the defense, did the court read the correct jury instructions?
Yes, Your Honor.
All right. As I said earlier, these jury instructions will be available to you when you begin your deliberations. This time for the closing arguments in this case. When we start here, we're probably going to be probably an hour and 10 minutes for the first two rounds anyway. If you don't think you can stay that long, once we begin the closing arguments, I don't want anyone coming and going or moving around in the courtroom, okay? All right. Y'all got the door back there. Don't let anyone in once we start these closing arguments. I'll take a break after the defenses have to let anybody come and go that wish to, okay? All right, you may argue for the state, and here's your instructions if you want them, okay? Let me get my card.
Ladies and gentlemen, good morning. We've been here a long time. Make no mistake about it. This case is about the death of Jimmie. Jimmie lived is true. Jay Lee, you heard all about it. Through the course of this trial, and I don't have very long, so I'm going to try to get to everything. But what the state has proven is that Tim Herrington lived a lie. Lived a lie to his family. He lied to Jay Lee to coax him over there, promised him to do something with him. That's what Jay Lee thought when he was going over there. If he'd have thought that he was going to be strangled to death, do you think he would have gone over? Ladies and gentlemen, that's embezzlement, that's coaxing. Not only did he lie to his family and his friends about his sexuality, being on the down low, they all thought he was into women. But we know there was a secret that he was keeping in his life. He lied to them, he lied to his church, his family, his friends. He lied to Jay Lee to get him over that night because he had a problem that he had to fix. Then he lied to the police about everything. Deception, lies. He had to protect that lie. And what did he do to protect that lie? In order to protect that lie, he had to get rid of the jail. And that's what he did. Now I want to go through and remind you about the proof. And before I do, you've heard four different you've been instructed on 4 different crimes: capital murder, first-degree murder, second-degree murder, and manslaughter. Manslaughter and second-degree murder is negligence. The actions that were taken by Tim Herrington to protect his lives is not negligence. Those don't apply. Mr. Horan said that we were going to offer all those and throw it all against the wall and hope something sticks. That's not what the proof is shown, and that's not what we've attempted to do. This is capital murder. That's committing murder in the commission of kidnapping. And I can tell you, in kidnapping, embezzlement, where it says you read about confining someone against their will, you heard another instruction that said that can be a bait switch. Coaxing someone over into deception, insincerity. That's what happened. That's what we proved. Now, earlier in the trial, when it first started, we put on a series of witnesses that told you about Jay Lee, about his life, about the truth he lived. When he was alive, he was on social media, he dressed fashionably, his life was vibrant. And how do we know that he is dead? Because the signs that his death left behind. You heard from Jennifer Buford. If you remember, she was the University of Mississippi advisor for his internship. He said that he had graduated. He graduated in social work, and that he was involved. That's the last thing to consolidate that degree was to complete that internship. And she told you that she had a lot of contact with him, and then it was stopped. She was like, that's not normal. You heard from Jose Reyes. He described how that they were good friends, that they had the same interests, they don't see area around that he was living his truth, that he was unapologetically fashionable. He talked to you about that there were things that he loved. He loved his Pomeranian. I don't know if you recall, but he had a Christmas card that he had done with his Pomeranian where they both dressed up in pajamas. He had things that he loved, interest. He was vibrant and happy. You heard Khalid Fears talk about his relationship just within the time they had at the park until July 8th when he heard from him that morning. He described him as vibrant and happy. That he, didn't plan to go anywhere, and he was not depressed. He was not dealing with any psychological issues. And then you heard from Stephanie Lee. And if there's one thing that the state has proven beyond a reasonable doubt through Stephanie Lee is that she knew that her son was dead. Because on July the 8th, 2022, it was her birthday. And you heard about their relationship. They spoke multiple times a day, morning, or lunch break, and at night. And this was her birthday. She woke up at 7 o'clock that morning to a message that Jay Lee posted earlier in the morning that said, "It's your birthday." You can tell her testimony about her son, that her son loved her. She loved him. They had a special relationship. And she said he wasn't planning on going anywhere. If he had planned to go somewhere, she would know about it. You heard testimony from all these witnesses about things that he cared about. He cared about his car. It was a unique car. He loved it. Had, the Ford Fusion 2014 with the gold stripe on it. It was unique. You heard them testify that he couldn't have gone anywhere without any kind of financial means. Everything was there, credit cards, debt cards. You heard them all testify how he used social media every day. I heard Jose Reyes say he was a little celebrity. People followed him on Facebook, Twitter, Instagram, Snapchat. And then after the morning of July the 8th, dead silence. You know from Jennifer Buford that he had the fundraiser project for his internship. He was still receiving packages of gifts for the children that were involved with CPS that were coming in after his disappearance. And you heard how much he loved that dog. And when that welfare check was conducted on his apartment at Campus Falls, the dog was there. And Jaylee's dog was there. He loved that dog so much that he had a dog bone on the back of his car, sticker that said, "I love my Pomeranian." And then we're going to get to what Miss Stephanie dealt with on her birthday. Not only her birthday, but now a day that she will forever, for the rest of her life, know is the day that her son was born. Talk about the welfare check on Jose Reyes. No activity of any kind on social media. You heard the condition of his apartment when UPD gained access to the apartment. There was nothing packed, no clothes missing, prized possessions still there. No indication that they were leaving, or planning to go there. And he had not had a history of ever doing that. Now then we'll get to the elements. Capital murder. Timothy Herrington is charged with capital murder. The court has instructed you on the elements. The elements are, we have to prove that Timothy Herrington, the defendant, identified by multiple witnesses from the stand, and compared to evidence in the case, photographic and otherwise, testimony. If you recall, the video surveillance from Malabar trails of the individual with the hoodie coming out, and then moments later, the video surveillance from Rockets, Keziah Carter said, that was Tim Herrington. Tim Herrington admitted in his interview to being picked up by Keziah Carter. Had to admit it because all those convenience stores had surveillance. Keziah Carter was a witness, knew him, admitted. On or about July 8th, 2022, all the evidence you have centers around that day. July 8th, text messages, silence. The silence after 6:03 a.m. from the last message from Jimmie. In Lafayette County, Mississippi, you heard the chief of police say that all of that evidence within that period of time occurred at Lafayette Police. So, proving date and location, Lafayette Place Apartments, where all of these activities took place. That is in Lafayette County, state of Mississippi. So we've proven that. Proven Lafayette County. The killing of Jaylee, that's a lot of evidence. That you have to take into account everything, all the history. And you begin with what? You begin with Timothy Herrington got a problem. What was that problem? Jaylee says in the message, I just wanted to be able to say I had you on the down low. And he left because of a disagreement. He left after that first meeting. Jaylee was not happy. Tim Herrington knew he wasn't happy because you'll see the nature of their text indicate that. The judge instructed you to use your good common sense and sound honest judgment. That's what it's talking about. All your life experiences collectively to be able to evaluate what this conversation is about. The problem was that Jaylee was leaving unhappy. He was living his life loud and proud. Timothy Herrington was living a lie. All of that was in jeopardy. Just graduated, had plans to be somebody. Plans to be somebody. He didn't want anybody to know his secret. Jay Lee heightens that problem by blocking Tim Herrington. Tim Herrington has no way to solve the problem. So what does he do? He goes into another account that Jay Lee didn't know, Red Eye 24, and he heard from Ben Douglas about how he identified who Red Eye 24 was. Major break in the case. Access Jay Lee's account and sees these messages coming in on Jay Lee's Snapchat. When Red Eye 24 makes a contact with Jay Lee says, dude, the TF is this. He doesn't know. Good common sense and sound knowledge. And then, this is where we learn about this group. And over here on the right side, Jay Lee tells him, you wouldn't do what I wanted you to do. And that was not a good word. And so, it continues on. You tried to do some questionable shit. That was too much. Have a good night, Tim. Tim still has a problem. Even Jay Lee thinks that, hey, you may just be trying to get me back over here so you can, beat my ass or something. Coaxing, luring, enticing. Where it says me, you tripping. I feel bad because we cool. So I ain't trying to end it like this. I'm trying to get them back. Jay Lee says, how are we cool? Right under that, coaxing luring says, I'm saying you're a cool person. It's flattering Jay Lee. And right there, Jay Lee stops talking about the problem that they had earlier and starts talking about sex, which is what they meant for. They quit talking about the problems and they started talking about fun. And right here in the message, Jay Lee says, the only way I'm coming over it is if you do something for me. It was conditional. And so what does Tim Herrington say? All right. More importantly is the timing of this. Because right after the conversation switches to the condition, you look at it, it's 5:45. And I do want to say where it says, why do you keep deleting that? I think when somebody's typing a message, you see it deletes. Why do you keep deleting it? And Tim says, all right, so Jay Lee says, all right, I'll come back, but later tonight. Tim says, no, don't wait later, come now. Jay Lee says, LOL. In response to Lori coaxing insincerity, right there on the bottom right of the message, possibly later tonight, Tim Herrington, LOL. Trying to reduce the disagreement and make it from there. Jay Lee responds with LOL. Then at 5:54 a.m., Jay Lee says, I'm coming over. I'm going to come over at 5:54. That's consistent with Campus Walk video reports where we see Jay Lee in the road with his key in his phone. Then, after 5:54, we know what Jay Lee's doing. What is Tim Herrington doing? Tim Herrington is searching. How long does it take to strangle someone? Right after this conversation. And then right after that, he talks about how quick it is for testosterone. That This is the Google search. You can see the time, 5:57 a.m., July 2022. How long does it take to run? Then 6:03 a.m., message from Jay Lee, Tim Herrington, says open. It's at the door. And that, ladies and gentlemen of the jury, is the last message Jay Lee ever sent. Why? Dead silence. Now, Tim had a problem. Jay Lee blocked him, red eye 24. Now, Tim Harrington's actions after Jay Lee sends that open message is proof of his crime. You've heard, you've got jury instruction on there about luring. You take into consideration what in the commission of a crime means. A continuous crime from luring him up over there to the actual act, and then what happens after. So he lured him over there, killed him, how do we know? He searched him, and then staged all of the evidence after that. So what were his actions? Well, in the interview, he lies to the police, number one, about the nature of the relationship that he had with Jay Lee. He says, oh, he just came over to give me a gift. We cool, everybody knows I'm leaving. You know, big man on campus, he just wanted to bring me a gift like everybody else. Maybe sat in his car for a little bit, and that was it. Lied to the police about the nature of the relationship. He also says in the interview that when, even in the second interview, he said, oh yeah, we just had a hookup and he left, you know, everything was fine. It wasn't like he left mad or anything. But they said, did you go anywhere else? And he said, yeah, we left at the same time and I went to Walmart. Well, if you look at the Walmart video, you look at the Walmart receipt, he checked out at 6:49. What did he buy? He bought duct tape. You've also seen video surveillance of him looking at a big trash can, roll trash can. He has no need for it. Lafayette Place Apartments got the dumpster. He says he's moving to Dallas in a few weeks. There's no need for that. Then he goes from Walmart in his Ford Escape, goes to the Links and gets a box truck when he doesn't have a job to do. Tyson King said we didn't have a job to do. His witness, his best friend, Ken from Grenada, said if we had a job down there, it included it. There's no digital footprint, no messages of any job whatsoever. He gets the box truck. Comes back home, going back to that place. And then he stages the car. If you remember, we did. He told the police that he went for a run. That was the only place he ever said he could back over to Grenada. And investigators mapped out the back road running 7.2 miles from 7. He was in Polybar Trails at 7:34, and he was driving by Cooknose in the box truck almost 30 minutes early. There's no way to make that. Lie to the police. Not only that, he's deceptive. He's trying to keep them away from looking at Jackson Road, which we proved right here. That at 7:02, Jay Lee's vehicle goes by Rainbow Cleaners. Not only that, what's tracking with that car? Jay Lee's phone. And then it tracks all the way to Molly Bar Trails at 7:25, 7:26. Jay Lee's phone is silent. 7:26. Then we have 7:34. the video footage of Tim Herrington running out of Molly Bar Trail apartment. And we have that connected to the surveillance of him getting in Zach Carter's car. One of the most important things is on July 10th, UPD issues a press release that's out on social media. And if you look on the right side of that screen, Tim Herrington searches Molly Bar Apartments. In that press release, Molly Bar Apartments is not mentioned. Not only that, law enforcement is not even aware that Jimmie's car is at Molly Bar Apartments. But Tim Herrington, he's already searched. Then he searches the Allie Costill case, and then searches for Tony Freeze. We talked about it daily. And throughout the next few days, he searches Jimmie Lee, body found in water. All those searches. And if you remember, he searched for police appreciation. If you remember that during this time that he's doing those searches about Jimmie Lee, but he never contacts the police to tell them, hey, you know what? He really appreciated the police and giving them the information. You know why I didn't? He said it. To me, this is the most important image. This is an image of 558 J. Lee leaving the apartment. In that picture, you can see the key to his car. You can see the phone where he was talking to Clea Fierce. And you can see J. Lee in his robe and slippers. The last person to ever have custody and control of those keys is Tim Herrington. The last person to have custody and control of that phone is Tim Herrington. You know that tracking that car, Molly Bar Trail's car, where that phone goes to. We know that key was there because we had to have the key to drive the car there. The last person to ever have his hands on J. Lee is Tim Herrington. And you know what? Because of Tim Herrington's actions, nobody was able to find the key, phone, or J. Lee. Because Tim Herrington didn't want to. And I submit to you that he should not get the benefit of getting rid of those keys. He should not get the benefit of getting rid of that phone. He should not get the benefit of getting rid of J. Lee's body. Ladies and gentlemen, prove our case beyond a reasonable doubt. We're going to ask you to go back to the jury, do your duty, and find Tim Herrington guilty of capital murder, ending J. Lee's life to protect his own future.
No, you ready? You ready? What now? All right, don't take a minute. And if you take a minute, set that computer up. If anybody needs to leave now, they can do so while they're or come in now. They can do so while they shut the computer up. But if you leave if the door is shut when you come back, you just out. You bring me some business, Sheriff. Have y'all got something out of Calhoun County today? I think y'all may have a plea out of chicken from the county. Might be chicken. Ready, Kevin?
Well,
All right. You said 4 minutes, didn't you? 4 minutes.
just want to make sure we're able to, hold this up. Got it? Mr. Chairman,
You may.
ladies and gentlemen, like Mr. Creekmore said when we started this case, anticipating that the state would put on evidence and then try to convince you that this number of options that the state has proven, you would choose one of them. At the conclusion of his argument indicated the only evidence that you should consider, only verdict that you should consider as capital murder. And I'm going to talk to you a little bit about the 4 options that they claim are in the instructions, but they're really 5 options. 4 options are capital murder, murder, first degree, second degree murder, manslaughter, and the 5th option, quite naturally, is not guilty. I want to talk to you a little bit about kind of where things started in this trial and go through a lot of different things. I'm going to try to make it through all the information that I have in 45 minutes, and that's not a whole lot of time to go over everything that I want to go, because there's a lot of questions that I have in all these notes that I'm going to lay out for you that I think there's problems in the state's case. Now, if I say anything or I represent anything that's not factual and you disagree with me, please say this out there, Mr. O'Reilly, you were not paying attention to that testimony, or you misheard something. You remember what you remember that came from that witness stand and you saw on that screen. Not what I tell you, not what they tell you. Just like when Mr. Creekmore told you that my client made a statement he was a big man on campus, that just wasn't said in this court. He did not make that statement. That's just an example of what I'm talking about. You remember what you heard, what you saw. And also, what you can do is consider your verdict or lack thereof based on a lack of evidence. That includes whether or not certain things that you felt like you should have heard, but you didn't. We're going to talk about those things right now. We'll start, first of all, and I've got so many questions on this pad, and ripped off 2 or 3 pads. I'm not as computer savvy as Mr. Creekmore, but I want to talk to you a little bit about some of the things that we have problems with. Why in the world would an agency who spent $30,000 not on technology as far as the computer stuff, all that's taken care of. Mr. Baker's training to do those things. They spent $30,000 and running, according to the chief, on collecting evidence from Jimmie Herrington's apartment, JD's car, and also from Tim Harrington's apartment car. $30,000. Not only did they collect this evidence and did something they've never done before. Never done before. Sent it to a lab out in California for the sole purpose of making sure they can extract every possible bit of evidence from Jimmie Harrington's car. Jimmie Harrington's car, Jay Lee's car, but obviously not, for whatever reason, Jay Lee's car. And it's not that big a deal, Your Honor, ladies and gentlemen, that they didn't go to Jay Lee's apartment initially. They needed to go over and get his toothbrush so they could compare his deal. But later on in the investigation, as the days traveled on, it seems to me that they would have gone over and said, hey, look, let's go in here and try to figure out whether or not somebody had been here after they interviewed all these people and said Jay Lee was having strangers and hookups coming into his apartment. Now look, folks, I'm not telling you they would have found anything over there. Not what I'm saying. What I'm saying is, on January the 21st, Jimmie Herrington became a suspect. That stopped all the other investigations. On July the 10th, 2022, they should have treated Molly Bar Apartments like a crime scene. They didn't do that. No indication whatsoever moving forward to September the 5th, 2024, when they got this lab report, that they should have gone back to Molly Bar for the purpose of drawing DNA evidence. No, that's not what I said. What I said was that they should have reinvestigated their case after September the 5th, 2024, when this laboratory told them there's no evidence. Should have at least gone back to Molly Bar like they did when they went down to Grenada and went over to Lafayette Place. That's the whole purpose of that piece of examination. Now, ladies and gentlemen, I want to go down a few things real quickly before we move into some slides. You know, he indicated on his opening statement that my client was deceptive. Let's talk about deception in this case. Jose Reyes, he indicated, hey, look, I can't tell you anything about his personal life. Don't talk to Janelle. Again, what I'm trying to establish here, I want you to understand here, that during the course of this investigation, they should have broadened their scope a little bit more. And say, let's look at these things going on in Jimmie Lee's life. Let's look at some of the other people outside of this direct circle. Let's look and see what's going on. What about Tyler Maddox? You know, he's the individual that not only gave deceptive information, he's the individual they eliminated by virtue of the fact that his ping location was at his house. Said he was looking at porn. In testimony here, the phone that put the person there. Again, I told y'all, and I told the officer, I'm not saying Tyler Mathis committed any offense whatsoever. All I'm saying is, information. Why in the world does Tyler Mathis get the benefit and not Jimmie Herrington get the benefit? Ping location, providing deceptive information. Why is the standard being applied differently to Jimmie Herrington in that circumstance? Khalid Pierce had to show him an exhibit on the stand
I'm trying, and that's
he was shown on the stand, the conversation that he had with Mr. Jay Lee about what? Choking conversation that they had between each other. That conversation pretty succinct, pretty detailed about what you like, what you don't like. That happened in June, shortly before Jay Lee had this encounter with my client. Khalid Fears was an associate, apparently, of Jay Lee. They must have been pretty good friends because they were talking at 5:58 in the morning, 3 or 4 minutes. And if you remember the conversation that we fought over in the courtroom, y'all heard us arguing about it, about what happened that particular morning, the conversation, Fears indicated from the stand that they had a conversation, and the gist of that conversation was what? Y'all remember? Jay Lee told him he was going back over to a place that he had been before, hooked up before, and they were going to have some fun. Now, I'll tell you that what's important about that conversation is, if you look at it, and the conversation on the screen pertaining to Mr. Fears, he testified, he remembered this conversation. Not only did he remember the conversation, he identified the conversation in the exhibit. This is exactly what he said. I like to go tap to tap. Fear. Okay, I'm not crazy. I feel like you are into BDSM, believe during sex. I enjoy a little mutual aggression. Correct. Oh, you like to choke and be choked. Now, that's not Fear. That's Jay Lee. What he testified from the stand, not only did he identify the message, he stated that he remembered that conversation specifically. Heavy on that. You have any kinks? I don't think so. I like to be aggressive and also put in my place. Now, ladies and gentlemen, I asked Brian Baker, Stacey Baker, whether or not he had investigated or looked into the Snapchat history or the Instagram history of Mr. Lee and even my client to determine whether or not there was any similar type conversations between them in the history of Mr. Herrington and Jay Lee consistent with this conversation. And I don't remember exactly what he said, but I think what he said, I didn't look. But wouldn't that be important to this investigation if they're going to claim that my client lured him over there for that to have occurred? Look back at things, pointing to Mr. Herrington had known each other 2 or 3 months. Wouldn't you look at their history to see whether or not Jay Lee, Jimmie Herrington, had any type conversation like that, or see that didn't go back that far, according to what we have in the cell record? All right. I want to talk to you a little about the first conversation, the first time that night, Jay Lee, Jimmie Herrington, any potential communication between the two. The first time was from not Jimmie Herrington. It was from Jay Lee. It said, you and Austin, on the screen. You and Austin. That came from Jay Lee to Jimmie Herrington. Conclusion of that text, that snap, what happened then? Jimmie Herrington didn't respond to that message. Jay Lee is the individual at the time of that text. It says at 2:24:44, Jimmie Herrington did not respond. Now I'm going to tell you, ladies and gentlemen, first thing I'm going to say is straight up front. We introduced the lock audit report, and the state was slamming and going crazy about it. That's not reliable. Well, this is what they gathered in their investigation. And I thought it was quite odd every time that there's a piece of evidence that supported the defendant. It's not reliable. The lock audit, the burglary report, y'all have both of those reports. You remember what Detective Baker said about the burglary? I'm going to speak to the burglary real quick. I mean, the lock audit. Go back to the lock audit, then I go to burglary. You remember what he said on the stand when he identified the document? We got an email telling us that lockout report. Wonder why. Ladies and gentlemen, I'm going to let you decide. It's in evidence. I'm going to let you decide if it's reliable or if you can consider it. But this is what we understand happened through the lockout. And it appears to be, according to the evidence that they got on the search warrant, they got a search warrant on July the 22nd, the same day they went in Mr. Harrington's apartment. They got it for the lockout for the resident key of his apartment. Search warrant returned for Jimmie Harrington's lockout. The door opens July the 8th, 2022, 6:41. Door opens July 8th, 2022, July 8th, 6:45. Ladies and gentlemen, y'all take that lockout with whatever weight and credibility that you want. But they didn't spend $30,000 or $3 trying to determine whether or not that was accurate. He just said it was unreliable. We said from the stand, said he had an email from somebody that said it wasn't reliable. It was never introduced in the evidence, folks. Never was. Now, getting back to conversations that morning, I asked the chief what conversations were in there that showed that the whole theme of this case had been proven that my client was getting out. And here's two guys, young guys, talking to each other. Nobody's looking into their world at all. You would think that you would have all kind of conversations where 3 days ago or the last time they hooked up, there would have been some beginning of some problems with their relationship. So you go to the next message, the Instagram message, where Jay Lee, this word say, according to the chief, one word in the Instagram message, number 4. I just wanted to be able to say, I had you, beat did. Now, Detective Baker, as you recall, when I specifically asked him, I said, Detective Baker, you can't tell us what the context of these conversations are. And I made reference to the conversation in the bottom of the Snapchat pertaining to something about, like to try to hurt me or something like that. He said, we have no idea what their prior conversation was about. That's exactly the point, ladies and gentlemen. We have no idea what these two young men talked about when they had a 14-second Snapchat conversation before he came over. We don't have any idea. But right here, Chief of Police, Oxford, Mississippi, when I asked, what information you have that supports the idea that he was about to out him? I just wanted to be able to say, I had you BDL. Again, Fonda had been the first guy experiment over. What does that tell you? What it tells me, and the reasonable interpretation is that Jay Lee's making a comment to Jimmie Harrington, hey, you had an experiment over. I don't know exactly what they're talking about, but it didn't sound to me like Jay Lee is making any type of threat to Jimmie Harrington that he's going to out him. That's what the state wants you to believe. But this man killed Jay Lee over this one word. He said, say. That's what he testified to under oath. You go down to the remainder of it. He said, also, I nutted on your floor, so you should get that up, by the way. Oh, and the nude was fake too. Back to block now. He's blocking Mr. Herrington, according to this, again, put anything in evidence that he had even blocked him that particular night. He said, back the block. Hang up on him. Our conversation is over. Now we go to the next Snapchat, and I'm going through these because I think it's very important. I've talked about the 14-second call. But I go down to the next one where the Snapchat red eye. Who the TF is this? Now think about that red eye account. Ryan Baker admitted that he had testified under oath previously that my client created that account for this transaction. We testified to, I showed it to him. It's for our testimony. He admitted, created that. I testified to that. Fundamentally false. I don't know if he had bad information or he misread it. I don't know. But that's a critical part of their case, whether or not this young man created this account for the sole purpose of luring him over. Not saying he didn't reopen it. That's not the point. They admitted on the stand. They do that all the time. Who the TF is, that's a response from Jay Lee to an invite from Jimmie Herrington. He's accepting that. Is what he's doing. The next Snapchat involves basically, he says, what did you delete? These are conversations, if you read them in context, what you can understand is Jay Lee is the one controlling this conversation. It's clear from that. Jay Lee is controlling the conversation the entire time through this Snapchat history. He says, what did you just delete? You made it like this. And when you get over here, you wouldn't even eat my ass 1 hour ago after I cleaned and everything. Then you proceed to nut in my mouth. Think about that. I hate to talk about this stuff, but this is what the facts are. Think about what happened later on in the fears statement when he says that he's going over there to do something we've never done before. It can't be that Mr. Herrington is going to give him oral sex. It can't be. This conversation right here contradicts that. Then he goes into all this information about effing nobody raw. Then he says, I'm going to stop harassing you now and that you want to stop blinking. You know how much of an asshole move that is. What he's saying is apparently he's upset because Mr. Herrington is telling him, maybe we're not going to look up anymore. Fine. Now, the Snapchat conversation next is the 14-second call that we talked about a few minutes ago. 14 seconds. They had a phone call and asked Mr. Baker about it. Nobody knows what that conversation was about. Nobody has any idea whether that conversation referenced any prior conversation or something they talked about when they got together earlier that night. Who knows? And I talked to y'all when I did open statements talking about speculation, wondering, drawing conclusions, making the quantum leaps. That's what the state wants you to do. That all this conversation, they won't connect the dots with speculation, no facts to support, because we just don't know what they were talking about. Now, if you look at the next Snapchat we're going to talk about, it's number 8 in my list, questionable stuff before. Try not to say cussing in here. Like you done did some questionable SHIT before. But that was too much. Do we have any idea what they're talking about? Absolutely not. There's nothing else in that text string tells you whether or not they were talking about our sexual activity, doing anything moving forward, or anything that they've done 3 months ago. It's not in there. We don't know. Remember Ryan Baker's testimony. We had no idea what they're talking about. And here we go. I'll come if I get head in front. Jay Lee is controlling the entire conversation between these two men. It's obvious and apparent from this conversation. You move on down to the conversation that they continue to have that night. All this is in evidence. You'll be able to look at it. But if you move on down and you look at some of the conversations that they had, it continues the same way. Have a good night, Tim. Only way I'm going to see you if I get head up front. And you keep going down, and Tim says, okay, why do you keep deleting? And that's just okay. Tim says, I'm sorry, I misspelled something. And okay, I'll do it. That's Jay Lee telling Jimmie, what are you deleting? He's the one that's being the dominant actor in this particular conversation. No, I'm fine. You know, if you do something bad, it won't end up good for you. Where in that conversation that they just had warranted some kind of comment like that from Jay Lee? Does that mean he's scared? No, he's the one saying, I may or may not come over there. If you look at the remaining of the text, he's the one that makes his comment. What prior to that warranted that? My client says, what do you mean something fast? Like hurt me or some shit. Where's the threat there from Mr. Herrington? Where is the alluring aspect of this conversation? Jimmie says, I know. And Jay Lee says, possibly tonight. But then he goes on to say, puts conditions on it. He continues to say, basically, I'll come later on tonight. Jimmie says, I told you I'm leaving later today. And we know that's true. Because if you go back to the prior text message about the screws, we do know that Mr. Herrington, all this is in evidence, talk about trucking company, he's talking to Tyson, he's talking to Mr. Love, Darius Love. He says on here, says to Tyson, I'm going to need those screws tomorrow. They go through this. I left them at Love's house. You're going to have to go get them. I'm in Hattiesburg. Then he talked about the tool bag. I'm going to leave around 9:30. He's telling Mr. Lee, you coming up? I got to go somewhere tomorrow. If you come, I'm letting you know. When Mr. Lee says, I'm probably coming, I am not going to be here throughout the day. If you come on. Now, I kind of skated over this, but y'all remember that Mr. Lee, the first time, 4 o'clock, goes to Mr. Herrington's apartment completely unannounced. Ryan Baker admitted to that. Completely unannounced. Second time he comes over after 14-second conversation. The last thing that happens at 6:03 is a Snapchat of open. No doubt about it. That does not mean that's when Jay Lee went in the apartment. It says open. At 5:54, he says, I'm coming. He says, what's that mean? Apparently, ladies and gentlemen, Mr. Lee consensually went over to Mr. Herrington's apartment. And we're going to talk just a little bit about how long does take to strangle. Nobody ever testified that the context of that search was, how long does it take to strangle someone? Now, if you recall, again, Mr. Baker, Detective Baker, testified August the 9th, 2022, that was the search. And he admitted when he testified to that, that was not factual. The text was, the search was, how long does it take to strangle? Do we know what context that was? Absolutely not. Do we know whether or not that was based on something that Mr. Lee had said to Mr. Herrington, consistent with the conversation that he had with Mr. Fears about what he'd like to do? Absolutely not. But there's a possibility there, ladies and gentlemen, and more likely, probably. Because how do we know that Mr. Herrington wasn't taking that very seriously? Because 7 seconds later, point in time, that got to type it in for Detective Baker. He was looking at something else. He was on Instagram. He was no more paying attention to that man in the moon. Agree with Detective Baker? Ladies and gentlemen, I'm going to go through some of the questions that we have about this case. Why in the world would these exhibits we talked about not sent to the lab? Why wasn't George Shiro here? You're not going to hear, you didn't hear from Mr. Shiro, but you heard from some of the stuff in his report. Why
Mr. Shiro about
Mr. Shiro,
I'm going to follow.
Mr. Shiro's report said they did not request fingerprints. I mean, request condoms, didn't request keys, latex gloves to be tested. None of those things were tested. Y'all heard that. I want to go through some more of the things that we have some concerns about. Think about this right here, folks. After the lab report came in, and they got it, and no doubt they at least had a preliminary report before, they go down to Grenada and start searching 2 locations. Lincoln Road, where they've been before, and they go down south of the Herrington home. We don't have any idea if they took drones down there, people down there, what they took down there to do those searches. We don't have a report. When they did the initial search, a Molly bar, do we know whether or not they searched it with men, drones? Who went out there and searched Molly bar trailers? Nobody. We don't know. We don't know how many people went out there and what they did, because we just don't have a report of those things. Ladies and gentlemen, answer this question right here, if you can. Why in the world, Detective Baker, Mr. Porter, would not provide a report on something they did 4 weeks ago? Why would they do that? Why would they not provide that report? The Burley report is in evidence. I want to talk a little bit about that. The Burley report provided Mr. Lee's car, the door opened and closed. Another fight in this courtroom about that particular item. The search warrant returned for the Ford Fusion Burley report at 7:34 a.m. Driver door open, closed. 7:34:48 p.m. The passenger door open. That's the Burley report that was introduced into evidence. You will have it. I encourage you to look at that page in that Burley report. 7:34 is what time, ladies and gentlemen. That's the time they claim Mr. Lee's car, 7:25, went in, 7:34. My client, close proximity at that time, sitting on camera, running away. 9 minutes from the time the car went in, time that my client, it can't be both, ladies and gentlemen. It can't be both. He can't be running away, and also he can't be opening and closing that door. Can't be. Now the burglary report, again, testimony from an officer that said, hey, look, you can't depend on that report. It's unreliable. He didn't tell us why it was unreliable, how it was unreliable, or what mechanism they proved that it was unreliable. All they said, it was unreliable. I want to talk to you a little bit about what happened in Jimmie Herrington's car and the times and things that they claim happened in the car. 6:03, they claim Mr. Lee at least said open the door. Later, maybe a minute later, maybe 3 minutes later, showed up Mr. Harrison's car. Went inside. Something happened. Think about the fact that he's in Walmart at 6:41. He's in Walmart. Checks out 6:49. If they'd gone in there and talked to the attendant and say, you know, he was looking at this garbage can, what did he say to him? They didn't do that. And why would Mr. Herrington be getting a garbage can in his car? Why would he be doing that? And think about this question that I've had ever since we started this case, and they give me the discovery in this case. It's like our report. How is it that Mr. Lee is at Mr. Harrington's apartment at a time when the lockout report says activities going on at that location? Ladies and gentlemen, I want you to look at that. I've got 2 questions that I want you to consider. Maybe the biggest 2 questions in this case. The first one is, how does the state establish beyond a reasonable doubt that J. Lee was not alive with Jimmie Herrington when the car arrived at Molly Bar Church? No one's testified that they identified Mr. Herrington driving the car or Mr. Lee. Think about the fact that fingerprints that were found in his car were J. Lee's fingerprints. Think about the fact that Mr. Harrington's prints were not found on the driver's side of the car, anywhere in the car. I already know.
Factual evidence.
Testified to, Your Honor, by the officer.
Let the JD's parents know what testified
Well,
to that.
I'm gonna, they make his argument, you'll have opportunity to do that.
The second question that we have, and probably the more important question is, how did the state establish beyond a reasonable doubt that J. Lee was not alive when Jimmie Herrington left for Walmart and returned? Jimmie Herrington got back in his apartment at what time? 7:02, something like that. He left Walmart, 7:09. He left Walmart 6:49. Why would he need a boxcar? Why would he need the garbage can? Didn't have a boxcar, box truck that was at the link. He drove back. There's no evidence whatsoever that Jay Lee not alive at the time. Think about why that's important, folks. It's because they haven't proven anything in the apartment to fire, hair, DNA, saliva, anything like that. If he was not alive in that apartment, he got back home. Now, think about this prospect. We talk about possibilities because the state laid out possibilities. Let's assume, giving the state the benefit of all their evidence, that when he left Walmart, Jay Lee was alive. Let's assume he left Walmart and Jay Lee was alive. Let's assume that Jay Lee was still in this apartment. Because if you look at the ping information that we had to introduce into evidence, not the state, we had to introduce into evidence the ping locations 715.
You have 4 minutes.
Thank you. 715 on. These are the ping 721. These are ping locations that basically tracks the area to Molly Bar Trails from Mr. Herrington's apartment. How can they establish Jay Lee wasn't in that car? How can they establish that he was not alive at Jimmie Herrington's apartment during that time? Mr. Herrington, possibly, we're talking about possibilities here. If you believe that Mr. Herrington found his way to Grenada, if you believe the theory that they got that he found his way to Grenada with a body, you believe it. If you find that, how can they state or prove that when Mr. Herrington went to Walmart, Mr. Lee wasn't still in the apartment alive? I'm asking them. Tell you that. How he went back to Walmart, 749, when he got the boxcar, which we know he had a reason to get the boxcar because the screws were there. How can they say he didn't walk up the steps, open the door, and Mr. Lee was there alive? Maybe, because we got the pin location stuff that leaving the apartment. What if Mr. Lee was there? Dead. Nothing in evidence that support that. Here. He could possibly be alive. Mr. Herrington came back. Because we do know this. He wasn't going to load up that car in the back of that car in the parking lot of Walmart. It made more sense if he got the box car and brought it back to Walmart. Box truck, brought it back to Walmart first. The court hasn't instructed you that if Mr. Herrington walked in that apartment, found Jay Lee, look at the lock, resident lock door. When the door's open, the door's closed, and that door, again, look at it. You cannot eliminate the possibility. Jay Lee was alive, he left to go to Walmart. He came back, he wasn't. That's a possibility. They've got to eliminate all the possibilities. Not us. They do. They have to eliminate the possibility that Jay Lee got in his car with Jimmie Lee. They got to eliminate the possibility that didn't occur. They can't do that. Jimmie Herrington, we're not ever denying the fact that he was running away from the car. We never made that a point of contention. They made it a point of contention. Having photographic evidence that both of those men were not in that car at that time. It's a possibility. I'm not saying we you'd have to prove that. I'm saying that's a possibility. Ladies and gentlemen, you've got to look at the burden of proof in this case. The burden of proof is beyond a reasonable doubt on all four of them.
Your
Take
time's up,
it.
Mr. Owen. Wind it up, time's up.
You got to look at four options. The only option that's possible in this case, if you take the state's case, everything they have most favorable to this. Most favorable to them is manslaughter. That's the best option with them, ladies and gentlemen. The most reasonable verdict, and the one that's supported by the lack of evidence, is not guilty. Thank you.
We got about another 20 minutes, y'all good? Y'all gonna need any time to set up, or y'all good to go?
Yes,
All right. Anyone wishing to leave, now you can. We're gonna have about, 20 minutes of testimony, once we get started. All right, all aboard that comes aboard. All right, y'all go ahead and close those doors now. Show the jury in. Are you ready? You ready? All right. Yeah, you got 20 minutes. All right, looks like everybody's back, and you may begin your final close.
Ladies and gentlemen of the jury, I have a short time to talk to you, so I'm gonna jump right into some of the points the opposing counsel brought up. He just came up here and attempted to mislead you. I'll start with the lock audit before we get back into the actual timeline of events, because the timeline matters. So let's look at that lock audit. It's in evidence you'll be able to take back. Opposing counsel showed you just the times of 7:34 a.m. But what he doesn't talk about is all the other times, or that this says Stephen Union on it. You remember, I believe Detective Baker testified that the lock report was not accurate, so it couldn't be used. Well, we know, according to the timeline, which is in evidence, it's in that jump shot, we'll get to watch it. Oh, look, 6:45 a.m., he unlocked the door. He's at Walmart at 6:49. Say he got back at 7:02, he unlocked the door. And then, remember, by 7:34, Mr. Herrington has to be all the way over at Boulevard Trails to run out. And according to his interview, he ran over there at a 4-minute mile. So, why is the next time 7:06? And then the next time the door is unlocked is also 7:06. Ladies and gentlemen, inspect all of this. I'm not gonna hide it from you, it's in evidence. Because when you really look closely at everything, because we're not afraid of the data. When you really look closely at everything, Tim Harrington's story doesn't line up. Ladies and gentlemen, he also attempted to mislead you when he talked about inveigle. He kept saying force. He said he was not forced to go over there. You will have these instructions in the back, and the judge read them out to you. What is the definition of inveigle? Ladies and gentlemen, inveigle means to coax. It means to convince. It's going to be this jury instruction that you'll have with you. The court instructs the jury that inveigle means to lure or entice through deceit or insincerity. Inveigling has no component of force, but only coaxing. Now, we heard those text messages, and we'll go through them. But the Instagram, that's where we first find out what happens. Because in the Instagram message, Jay Lee writes, after leaving Tim Harrington's apartment for the first time, 4:36 a.m., he texts, I just wanted to be able to say I had you beat DL. Again, fun to have been the first guy. Experiment over. Now, opposing counsel states that that's not Jay Lee threatening him. It's not our position that Jay Lee was actually threatening him. It's about how Tim Harrington perceived it. As someone who is deeply closeted, who's on the down low, who doesn't want people to know. You heard his family, none of them knew. Tim Harrington wasn't publicly out. Look through his Google search history. You'll see the kind of things he Googles. It's all finance. It's all celebrities or rich celebrities. Things that he's aspirational to be. Until this happens. then all of a sudden, he's either into true crime or Googling how long it takes to strangle someone right before the person he strangled shows up. So that first message, he sends that, and then he blocks it. And then he reopens the message. He says, all right, noted on your phone, you better clean that up, back to block. Jay Lee did not re-engage that conversation. The only reason it happened again is because Tim Herrington contacts him over an anonymous account. Now, it's never been the state's position that Tim Herrington created the account just to contact Jay Lee. He has another account. He couldn't contact Jay Lee on the account he was blocked, well, because he was blocked. And we know that Jay Lee didn't know who it was because he says, who the F is this? They want to mislead you. They want you to read things that are not there. Just read the messages. They speak for themselves. We don't have to make anything up. We don't have to pretend or read anything into it. I think who the F is that speaks for itself. And then what happens? What happens right after that? Right. Tim Herrington doesn't respond, hey Jay, it's Tim. Since we're in a good place, we're in a good relationship and everything, he tries to call him 3 times or FaceTime after him, over and over. You know why? Because he didn't want to put it in writing. That's why he's using an anonymous Snapchat account. And then what happens? After Jay doesn't answer his 3 calls, Jay says, well, actually, I believe that's actually when the 14-second Snapchat call happened. And when you look at our timeline evidence, you'll see that. That's when the actual Snapchat call took place. That was 14 seconds. That's how Jay knew who it was. So they pick up with their same conversation over again. And Jay Lee says, what did you just delete? You made it like this. And what does Tim say? Come back. He asked him to come back. Now, opposing counsel wants to say that Jay showed up unannounced. And truth be told, we don't know how Jay got to the personal counter, but we do know that Tim didn't mind because look at his interview. They want to skip over what he told the police. After he lied the first time. The second time. In that interview, he says he came over like usual and he gave Tim Herrington oral sex like usual. Watch that interview. You'll have all that. He could have said that he showed up unannounced, I didn't know what was going on. He forced me to do these. No. But he said, like usual. That's what they usually do. So then, the conversation continues. Now, remember, Jay knows who this is. What did you just delete? You made it like this. Come back. Jay Lee doesn't respond within a minute. You coming or not? And what does Jay say? He says no. Opposing counsel wants to frame this as if this is not obvious what's going on. Someone is asking someone to come back who was just in a fight with them. That's very clear. From the Instagram messages where it was blocked. And then as we go on, we find out what the fight is about. And Tim asks, why not? Well, Jay tells him, you wouldn't even eat my ass 1 hour ago after I cleaned and everything. Then you proceed to nut in my mouth. Hopefully you ain't been effing nobody raw. And then ask if I'm going to stop harassing you now and that you want to stop linking. You know how much of an asshole move that is. That's what happens the first time. It's right there. Jay Lee is upset, not just because Tim wouldn't reciprocate, but it's all the other actions. He treated him like crap. They had a sexual encounter. Tiffany Herrington was satisfied, and then he said, okay, you need to get out. And you need to stop contacting me. We're not going to link anymore. And Jay Lee says, do you know how much of an asshole move that is? tells him he's foul. And then ladies and gentlemen, the defense would have you believe that Tim Herrington, or that just is being pursued by Jay Lee in these messages. The messages literally speak for themselves. And then you have to ask yourself, when we're looking at this, inveigle means to lure, entice through deceit or insincerity. Only coaxing. Coaxing means to convince. Jay Lee has said no once. And Tim, he told him why too, because you treated me like crap right before this. And Tim proceeds to convince him. Jay Lee says, you've done some questionable shit, but that, treating me like that was too much. Tells him to have a good night. Second time, Jay Lee tells him, no, have a good night. The next thing, Jay Lee says, yeah, now it seems like you're just trying to lure me over there to beat my ass or something. And why is that important? Because think about the earlier conversation right there in the text messages, where he told him how he just treated him. You just treated me like crap. You told me you don't want to see me again. You told me to stop contacting me. Now you're asking me to come back. Why? That's unusual. You're trying to lure me. Of course Jay Lee feels like he's trying to lure him over there. He just treated him horribly. Then, Tim says, you tripping. I feel bad because we're cool. So I'm not trying to end it like this. Again, telling him he doesn't want it to be over. He doesn't want to end it like this. There's nothing more to read into that. It's right there. Jay says, how are we cool? You barely want me to text you. Opposing counsel skipped over all these messages when he was going back through because he doesn't want you to see the real conversations. He wants to make it look like Jay Lee was inviting himself over. Jay Lee was pursuing. Jay Lee is asking Tim, how are we cool? You don't like me. You don't want me to text you. You just told me that you want to stop linking. You just told me to stop harassing me. Now, you're acting all different. That's obvious. Then, Tim says, you're a cool person. They go on to talk about when was the last time that Tim had sex, had that conversation, and what do we see? Jay says, because he sees Tim trying to invite him over, and he clearly likes Tim. And so he says, okay, I'll come over. If when I get there, I'm gonna have oral sex. You're gonna give me oral sex. And Tim, rather unenthusiastically, I might add, says, okay. So much so that Jay doesn't even know what he's talking about. He says, just okay? And Tim later says, I'll do it. See, that's important because that's the lie and the deceit. Think about Tim's interview, which I want you all to watch. The defense says that we don't know what the thing that's ever been done before is. Tim told us what it was in the interview. Tim says, oral sex. He says, I've never done that before. He says, he invited him over to make it up to him because he's never done that before. That's the thing. And it's very obvious from the interviews, from the text message, and from what Jay even said. Opposing counsel put that 14-second phone call. He wants to put it where he thinks it should go to help his story. But where it actually went was right after Tim called Jay 3 times Jay didn't know who it was. And then the 14-second Snapchat call. That's what actually happened. And the truth matters. The timeline matters. Then, again, Jay Lee says, you know, if you try something fast, it's not good for you. And Tim says, what do you mean? And Jay says, like, try to hurt me. Because you know why? He's still suspicious because Tim is acting different. He says, you barely ever want to text me earlier. He says, this is a man who just told him to get out of his apartment. He didn't want to leave anymore. Who just told him that he should stop harassing him. And all of a sudden, he wants to invite him over to do something, to give him oral sex, which he has never wanted to do. And Tim has never done. And so, of course, Jay is suspicious. To lure or entice through deceit or insincerity. And how do we know it's insincere? Because right after Jay agrees to go, which again, he says possibly later tonight, that's not good enough for Tim. He said, I told you I'm leaving today. Jay still wasn't going to come right then. So Tim had to convince him to come. I told you I'm leaving later today. So Jay then, he says, I'm coming. And once Jay agrees to come, you'll notice Tim never responds. He just needed to get Jay there. And right after that, he makes that Google search. How long does it take to strangle someone? Now, when Detective Baker testified, he was clear. He's not saying that Tim intentionally Googled how long it takes to strangle someone who got deal. We will never know. What we're saying is that he typed in how long it takes to strangle, and when you type that in, once you get to the end of strangle, the options, like on Google, trying to predict what you're going to say, Gary Petito's the first one. So if you're moving fast, you either type that out or you click it. That's how the search is logged. That's why it's a search. Otherwise, it wouldn't be logged. They say that an Instagram activity. Detective Baker testified about that too. We don't know if that was a notification that popped up from Instagram. It just says Instagram activity. You can't tell if he actually moved to the Instagram app. You just know it's activity. And since it is such a short 7 seconds, ladies and gentlemen, you can deduce that it was probably a notification that popped up. Because that's what makes sense. Opposing counsel wants to talk about possibilities, but we are not here about possibilities. We're here about reasonable doubt. A lot of things are possible. It's possible that elephants could rain from the sky. It's possible that anything could happen. To say anything could happen. Reasonable doubt does not mean all doubt.
You have
It's
2
about-
minutes.
Thank you. It's about what is reasonable. He asked 2 questions. How do we know Jay Lee was not alive when the car arrived at Molly Bar Trails? And we know that because at 7:28, the phone shuts off. And that's right before he gets to Molly Bar Trails. And by shuts off, we don't know if it was broken, we don't know if it was damaged. But we also know that from the testimony of Jose Reyes and Jay Lee's mom, that he never let anyone borrow his car. Jose said he don't let him go get some gas to gas it. So we know that. We also know that when the car is found, all his things are in it. The things he would need to move on, to live a life. He says, 2, how does the state establish that Jay Lee was not alive in that apartment when Tim returns from Walmart. Tim Herrington says in his interview that Jay Lee left a little bit before him. That Jay Lee left before him. Watch Tim's interview. He says he left, Jay Lee, and then Tim left. And then after that, he says he went to Walmart. We also know from witnesses that said that Jay Lee never had any reason to be at Molly Bar Trails. In fact, he didn't really know anybody over there. They talked about talking to people over at Molly Bar Trails who said that Jay Lee was never over there. And one big point.
That's not my ring to be sure, but I was gonna ring if you didn't. You can wind up real close.
I will. One big point we know for sure is that how did Tim Herrington get to Molly Bar Trails? When we asked those two questions that he asked, Jay Lee was not alive, and Jay Lee never left or was alive when he returned to the apartment. You heard the testimony. There's one way in and one way out of Molly Bar Trails. One way in and one way out. You never see Tim Herrington run in. Not only do you never see Tim Herrington run in, you do see a few cars go in. But if a few cars go in, if Tim Herrington was in one of those cars, why didn't he just tell that to the police when he talked to them? And if that's the case, when he got out of the car to pretend the job, why did he catch a ride immediately after running out of Molly Bar Trails to get into another car to take him home? None of those cars dropped him off. It's not about possibilities. What is reasonable? Sometimes the obvious answer is what it is. Ladies and gentlemen, July 8th has always been a special day in the Lee family. Stephanie's birthday, and she testified that every year her son, Jay, calls to sing her a happy birthday. She's never going to hear that again. She's never going to call again. But today, it's Tim Herrington. Tim Herrington's Day. It's time for him to be held accountable for what he's done. So when you go back there, look over all the evidence. Take your time. Dive into the data and find the only verdict that justice demands. That's guilty.
All right. Ladies and gentlemen, jurors, can y'all go to work? As I told you, when we came up there, we had spares, so we're gonna be here a while. And those alternate jurors will be, William Fargo. Got that left or not, Mr. Fargo. Denise Cole. Given to you, not if you have a verdict, okay? But y'all three all come back out when you get your personal belongings. All right, if somebody would, if that's an exhibit that's been displayed there, let's make sure you gather up all the exhibits before you go. Y'all, all right. All right, I'm not gonna say, well, let's wait for the door closed. service. I know I told you was gonna ask a lot of you, we have. You've been away from your home and your family for a good while now. If you wish to discuss your jury service with anyone, you can. If you wish not to, tell them you don't want to, okay? I don't think you'll have any problem with them persisting, but if you do, let us know. Your guess is as good as mine as when this jury will reach a verdict. If you want to hitchhike home or something before then, if you got somebody that could come this way, when the jury reaches a verdict, we will carry a bus back. You're welcome to stay in the courtroom. You can move around Oxford. If you decide to leave and move around Oxford, I guess your belongings are all still at the hotel. If you want to return to the hotel, you're on your own to do what you want to do. Your courtroom is open to you. Your hotel room is open to you. Go and do as you see fit. As I mentioned, if you want to talk about your service, have it. If you don't, go. Okay. But thank you all, and I'm gonna let them come back through around here and come out through my chambers area here. What this way, okay? Yeah, the three here. Make sure we've got all the instructions and the exhibits together, okay? Back to the hotel, have at it, but since I can see it from here, I think you'll probably be okay. What's that? Make sure you got all the counsel in their use any exhibits that were marked exhibits in your presentation.
I did not.
Okay, did the state?
Yeah, he gave them back.
Okay, everybody make sure all the exhibits are marked, all the instructions are back together. We need to talk about, has there been any thought given to, in the event that, oh, I'm sorry. If you, Lynn, if you would, shut the door, please. Shut the door, please. Has any thought been given to, in the event that the jury wants to view any of these videos, do we have some device that's not contaminated with anything else that can be used? What have you got, just for the record? Is it already back there? Is it clean of any, is it a clean computer? All right. I'm gonna let the clerk have a computer back there anyway. If they need any help starting or anything, Lynn, let us know and we'll make arrangements, okay? All right. Go ahead and get these exhibits back and the instructions back. I will say we've got a pretty good crowd gathered here today. I know everyone here is interested in the outcome. I know it's important to everyone. In all likelihood, sometime today, we'll have a side that they feels that they've won and a side that feels they have not won. I don't know, have any idea more than y'all, anyone else do. Anybody here has heard the same testimony that I have. I will say this, whether you consider your side having won or lost. I've been in this business a long time, you can tell by my gray hair. But on both sides, I think that the evidence was gathered, the cases were investigated, and the case was prosecuted and defended as thoroughly as any case that I've ever dealt with. So whether you win, your side's win or lost, I assure you that they put on their best game and their best performance. And I appreciate you attorneys working so hard and getting the facts out there. I'll say that. That being said, you're free to go. You're welcome to stay, okay? Court being recessed till we have a verdict. vital.
Good afternoon, council.
Good
Good
afternoon.
afternoon.
Okay, I'm calling the case of State of Nevada versus Diablo Delone Redden, case number C 243805558-1. The council who's present, please identify yourself for the record.
Good morning, Your Honor, or good afternoon. Liz Mercer and John Giordani for the state.
And good afternoon, Carl Arnold for Mr. Redding, Your Honor.
And I see that he's present and in custody. Okay, this is the time set for sentencing. Are we ready to proceed?
We are, Your Honor.
Your Honor, I just want to make sure that you have received our sentencing memorandum with Dr. Paglini's report dated August 1st, 2024, Karen Springer's affidavit dated December 5th, and Dr. Paglini's current update dated December 5th.
Yes, they were very lengthy, single space. I even read them, Mr. Ron.
I knew you would, Your Honor, so thank you.
Okay, all right, Mr. Redden,
Yes, I,
okay, I need you to stand, sir.
okay. Sorry, I feel a little nauseous, the thing right here.
Are you okay?
Yeah, I feel embarrassed like you.
Okay, all right, sir, I have your guilty plea agreement or memorandum here in front of me, which, as you know, was filed in open court on September 5th of 2024. I canvassed you on this guilty plea memorandum. You signed it, and you answered all of my questions. I am adjudging you guilty, but mentally ill, to committing the following crimes. Count 1, attempt murder, victim 60 years of age or older, a category B felony in violation of NRS 200.010, NRS 200.030, NRS 193.153, and NRS 193.167. Count 2, battery on a protected person resulting in substantial bodily harm, victim over 60 years of age or older, a category B felony in violation of NRS 200.481, and count 3, intimidating public officer, a category C felony in violation of NRS 199.300, count 4, battery on an officer resulting in substantial bodily harm, a category B felony in violation of NRS 200.481, count 5, performance of act or neglect of duty in willful or wanton disregard of safety of persons or property resulting in substantial bodily harm or death, a category C felony in violation of NRS 202.595, count 6, battery by prisoner, a category B felony in violation of NRS 200.481 subsection 2F, and count 7, unlawful act relating to human excrement or bodily fluid, a category B felony in violation of NRS 212.189. Does the state have anything to present?
Yes, Your Honor.
All right.
Thank you. Your Honor, before I begin my argument, I would note that he has 16 days credit for time served, and that is because he's been under sentence of imprisonment in the case that he was sentenced on in front of Judge Holtis when the events in this case took place. Additionally, the state is requesting a total of $61,318.41 in restitution.
Okay, $61,318 and
$0.41 in restitution, and it should be paid to CCMSI. That's the company that administers the workers' comp claims for the 3 officers involved in this incident that sustained injuries. As the court's aware, we filed a very lengthy and detailed sentencing memorandum.
I know, I read that too.
So I'm not going to spend a whole lot of time regurgitating everything in there, but there are some things that I want to point out for the court. Initially, as indicated in our sentencing memorandum, we are asking for significant prison sentences as to each course of conduct, and we're requesting that as to each course of conduct, the sentences run consecutively to one another.
Well, did you have some run concurrent? I'm looking at page 3.
So the counts would run concurrently as to the victim, but consecutive between the various victims, essentially.
Right.
And so it's the state's position, Your Honor, that the defendant's very lengthy criminal history, his demonstrated lack of impulse control, and his inability to completely accept responsibility for his conduct as well as the egregious actions in this case warrant such a significant sentence. I would note that his criminal history dates back to 2011. In each event, as you read through the reports, they all stem from his poor impulse control issues. And prior to this case, he was convicted in 12 other cases. They all involved some level of violence. In 9 of the 12 cases that he committed new offenses while charges were pending. And the longest that he went without reoffending was a period of 2 years and 2 months. The only time that he did not commit new crimes was when he was in custody, Your Honor, and subject to detention. I point these things out because it is obvious from his demonstrated failure at supervision that probation is completely inappropriate for someone like Mr. Redden, and he should be detained for as long as possible, because the only time that the community is safe is when he's in custody. He has demonstrated that he's incapable of being rehabilitated or reformed. When you look at his record, he was actually in mental health court for a total of 5 years. And even after that 5 years, he committed 2 more violent offenses. One was an attempted home invasion and committed in September of 2021. And then in April of 2023, he committed the assault with deadly weapon that was dealt down to the attempted battery, resulting in substantial bodily harm, for which Judge Holtis sentenced him. And then in January 2024, when he showed up for sentencing in that case, he committed the horrific crimes in this case. Additionally, as the court is aware, you were provided 2 expert reports, one from Dr. Rowley and one from Dr. Paglini. Both doctors found that he was not suffering from any sort of delusional disorder at the time that he committed the crimes in this case. Dr. Rowley noted that he has problematic insight and judgment, but noted that those issues relate to personality issues and not his mental illness. And in Dr. Paglini's report at the bottom of page 17, he noted that he has no insight or self-awareness pertaining to his violent history. On page 26, page 34, he noted that Mr. Redden's impaired judgment is based on personality dynamics and not psychosis. So Mr. Redden was perfectly aware of what was going on at the time he committed the crimes in this case. I think that what you notice pretty glaringly when you look at his criminal history is that Mr. Redden has repeatedly failed to recognize that he is the common denominator in these cases. It is his actions that end him up in situations such as this. It is not him being victimized by other people, it is his conduct. And until he accepts responsibility for reforming his conduct and for his poor impulse control, he's really incapable of being rehabilitated, because if he doesn't believe that he's done anything wrong, what's the incentive to improve? As to the facts of this case, Your Honor, Mr. Redden cannot be permitted to retaliate against a sitting judge and officers of the court when he's displeased with the outcome of a criminal case. Judges need to be free to make the rulings that they believe are appropriate based upon the information presented to them. And due to his extreme conduct in this case, a heavy sentence is warranted, Your Honor. It is my understanding that Judge Holtis does not wish to address the court personally, but she has prepared a statement that Mr. Giordani will read to the court with the court's permission. We would ask that it be read last, as it is essentially a victim impact statement, which would statutorily be provided to the court last.
Thank you.
Your Honor, I'll let Mr. Redden speak first. He wants to address the court.
Miss Judge Susan H. Johnson, I don't understand why the state is like really going after my character. I mean, I've always had problems since I was a little kid of like psychosis and being in big crowds and always feel like my life is in danger. I didn't know, being a young person, even in middle school, elementary school, knowing that like I fear for my safety. I'm just being me, going to school, growing up, trying to do the right things. I never get tired of trying to do the right things. The state just said that I have no no remorse. Like, I feel like Judge Johnson, she doesn't know me. I understand she's doing her job. I'm not mad at her for that, but I know that I'm not a bad person. And I'm thinking, like, even she knows that, but I'm sitting here like she's doing her job, you know? And I believe that you all know that I'm not a bad person. I'm not an evil person. When I came to court on January 3rd, 2024, I was listening to music. I was in a good mood. I had a stable place to stay. I was trying to get a job. I did not catch any new charges. I'm not a bad person. I don't understand why the state is trying to prove me as a bad person. I understand they have a job to do, but this is just, it's not right to me, you know? I'm not an evil guy, and I just keep going after me. I see spirits, I hear voices. I've been going through this for over a decade now, really since 2012, you know? And I just feel attacked or just not safe since I was a little kid. And me growing up, I didn't know that I had these problems. In 2022, I came to prison for the first time. I accepted responsibility for my actions. When I did what I did, I committed a crime in 2020 of December. It was 4 years ago. I paid my debt to society. I got out thinking I'm gonna get work. I was really sick and ill. I was very malnourished. I don't complain about things. I don't point the blame when people have done me wrong. I still treat everybody right. And the state just stated that I have no remorse and they feel like I'm a bad person. I just don't understand why are they coming after me like this. But I understand they have a job to do. When I came to court, I know for a fact, Judge Johnson, I met Judge Holtis in 2023 of October. And you know what she told me when she revoked my probation? She said, Mr. Redden, I hope you get the help you truly need. I said, thank you so much. And I meant it. I know for a fact I'm not an evil person. I think all of you guys know that, you know? But I'm not gonna use stuff like me being on camera for my actions, you know? But I know for a fact that I cared about Judge Mary Kay Holtis's well-being. When I left my house that day at 8 Rose Circle, I left my keys to my apartment, to my family, you know? And I got in the car and I came to court doing the right thing. I gave up everything, like in case I don't get probation. I was like, well, at least I know I tried. And I'm sitting here talking to Judge Holtis, Ms. Johnson, and I swear I started hearing voices in 2012, really in 2014. I'm gonna make a long story short, but I just want to get the facts out because I don't want the state. I understand they have a job to do, but I'm not a bad person. I'm not an evil guy. But I came to court and I'm in a good mood. I'm listening to music on my phone. I'm like, oh, whatever. I remember I about to hug my mom, my foster mother who raised me since I was 11 years old. I hugged her like, just in case if I don't get brushed. You can see it in the videotape, so I was in a good mood. I don't want to be known as a person who has mental illness because those people get attacked. I've heard so many people who have mental illness commit suicide and kill themselves and commit things that they really don't mean. I hope I don't have mental illness. I try not to have mental illness, you know. I don't want to be known as a person who has mental illness because they get attacked, you know. So I try my best when I'm going through all these problems. Since I was a little boy, like I told you, I didn't know I had these problems until 2 years ago. I was sitting down in prison and I had this dictionary, and I was like, oh, that's what that word means. That's what that really means. I didn't know that. Oh, stuff has a deeper meaning. You know, like, wow, I never could think like this. I was in prison with nothing to do. I did 12 to 30 months. I did 15 months total, and I cleaned up my sentence. I paid my debt to society, and I got out as a good, productive member of society. I didn't know and didn't want to believe that I had mental problems. You know, I started seeing spirits. November 2022. I'm not making excuses for my actions, but I'm saying I'm not a bad person. And I know that I did not intend to kill Mary Kay Holtis. I know I cared about her well-being, Judge Johnson, you know? And I came to court that day and I was talking to her and I told her I never stopped trying to do the right things. I wasn't pointing like, oh, this person did this to me. I deserve a chance of probation. Like, this is not fair. All I see was red and all I heard her say, oh, this, like she said, and I finally watched the whole video. I was standing here in the courtroom with all of you guys, and I finally saw the entire video, Judge Johnson. I'm like, I can't believe this. And I wasn't even mad at Michael Lasso. I was like, I commend him on doing for what he did, and everybody in the prison trying to make me hate him and hate the judge, and I'm still trying to do the right thing. They putting stuff in my ear and I can't get away from it. But basically what I'm trying to say is everything I've been doing, this is just like, this is not right to me. But like I said, I know the state has a job to do. And basically what I'm saying is, I know I cared about Mary Kay Holthus, to make a long story short, but when I was sitting here talking to her, I swear this has been happening to me since 2012. I saw nothing but red, and I heard her say, I think it's time for a taste of something else. I saw nothing but red, and I don't remember doing anything except for jumping on top of her and doing this to her robe. I was like, why are you doing this to me? That's what I wanted to ask her, if I think I know myself, but I'm not really sure. That's the only thing I could come up with. I had 11 months, but I can't really come up with anything. But I know that I cared about Judge Mary Kay Holthus's well-being. You know, that's all. Thank you.
Can you sit during my,
Sure.
and, Your Honor, again, I hear the state in that they're saying it's a lack of impulse control. I agree with that. However, he's adjudicated guilty, not guilty, but by mental illness. And so, bottom line, his ability to control his impulses are vastly different from my ability, from, Mr. Giordani's ability. He does not have the same ability to control his anger, what he's going to do, because as you saw in Dr. Paglini's report, from day one, from birth, he has had this mental illness based upon his mother's drug use at the time of her pregnancy, the stuff that he saw during him growing up, going through different households, going to a stable home in his foster parent, but he was still unable to comply with just normal behaviors. And that all of that should be taken into account. I think this case starts again in April of 2013. The 18th is when he was arrested after going after his brother-in-law with the baseball bat. Basically, again, this was during a period of time where he wasn't doing his medication. He was off his meds. He's going through his paranoid disorders, whatever those that were outlined by Dr. Paglini. And this whole incident arises from that. He gets into court and he's deemed incompetent. He can't comply with the normal court proceedings that were occurring. He refused transport 3-4 different times. Then he gets into court and he's unable to control himself. Why? Because he wasn't on medication. He goes to competency court. He is eventually given medication to subdue the voices, to subdue his impulses, and he's able to comply. That person that is able to comply is the person that we see today, Your Honor. We made sure that he was on his medication. We asked the prison. I asked him personally. That wasn't done prior to his sentencing in the original case that occurred out of the 2023 incident. And that's the other point I wanted to bring up. This case is very different than most of the cases where we have a mentally incompetent person in the court proceedings. Usually, their incompetency keeps them in custody. This is the first that I'm aware of that they're actually released out of custody. He was released, and then he had the inability to get back on the medication that was being given to him free of charge at Clark County Detention Center. He tries to make appointments, as you saw in Ms. Springer's affidavit, to get this medication. For 2 months after his release, which again is an occurrence that I haven't seen before, he's unable to get that medication. Of course, he's gonna slip back into the same impulsive behaviors that he had before. Of course, he's gonna slip back and not being able to suppress the thoughts and delusions that he was having. He went back right to what we saw in August 2023. And so again, that should all be taken into consideration. The state is asking for consecutive time. Part and parcel, his mental illness continued from the 2023 incident all the way until today. He was never released after sentencing in January 2024. We're asking, and I'll get to how much time, but we're asking that it all be run concurrent with his sentence that was received from Judge Holtis, the 1948, to whatever Your Honor believes is appropriate today. And the reason why we're asking for this to be concurrent is simply because he didn't have the chance to get out. He didn't have the chance to rehabilitate himself. He didn't have the chance to demonstrate to the court that, okay, he learned his lesson. He was still under the state's control during the time of his sentencing. The same state that we forgot to inquire prior to his sentencing, whether he was under his medication, the same state that didn't provide him with his medication, the Mojave Health Clinic, being it during the holidays, was unable to give him an appointment. I believe that this case has shed light on people's mental illness and what we have to do to, number one, bring them into court and understand what they're going through. And I don't think the answer is just throw away the key, give them a whole bunch of years. That benefits no one. We understand that a message has to be given. Since he's been on his medication, as you see him today, Your Honor, he's being courteous, he's being compliant, and he's deeply remorseful about the events and what happened that day. What I haven't shared with anyone other than my staff, and me and Mr. Redden talked about it. The first time that he saw the entire video was right here in court during the presentation of evidence. I was sitting right next to him. His reaction was very visceral. It was almost like he wanted to throw up. He called himself a monster. He did, Your Honor. That's me. I'm a monster. I can't believe that I did that. I did not mean to hurt that woman like that. I can't believe that I did that. That's what he said sitting in the same exact chair during trial. I believe he just, like he said, he doesn't have any specific recollection of coming over the bench, but when he saw it, he was deeply remorseful. He was just shocked about how he could act that way. And I think, Your Honor, all that should be taken into consideration. He understands a difficult position that you're in. We talked about this at length. I told him, there's just no way you're going to be granted probation in this matter. That was spelled out to him. Also, what was spelled out, there has to be a message that, you can't come flying over the bench because you didn't get the sentence that you wanted, or you're upset with the sentence. It has to be protection to your honor, it has to be protection to the prosecutors, it has to be protection to everyone in the courtroom. And so that message has to be sent, so we don't have the next Joe Schmo that gets upset and takes it out on court staff or anybody surrounding them. He understands that. And with that understanding, he knows that he has to do some time. What we're asking for, Your Honor, is a 4 to 11 year sentence. How we got to that was a 2 to 5 on counts 1, 2, 3, 4, and 5, all to run concurrent. Consecutive to that, and by statute, counts 6 and 7, we're asking for a 2 to 6. So the total of that and the count 6 and 7 are running concurrent with each other. So, and we're asking also that be concurrent with his current 19 to 48 sentence. So we're asking for a 4 to 11 year sentence. I think that's sufficient considering, number one, his mental illness that he was under, his inability throughout life to control his actions based upon that mental illness. The state and our failure to be able to recognize mental illness and what we should do in terms of addressing it, getting him the type of help, and not just throwing him into prison, but figuring out ways, which we're not equipped with, but a psychologist would be more adept to figure out how to help these individuals and give them a life plan or whatever it takes, so when they do get out into society, they're able to comply and have appropriate behavior. As you saw from Ms. Springer's affidavit, this was an individual, coming off of his meds that still wanted to comply. He had a living arrangement. He was trying to get to his appointments. He even obtained a job at the Teamsters union and received a dispatcher job, while he was waiting for sentencing that day. This is a person that can and would be able to do it given the appropriate help from a psychologist and mental health counseling. So we're asking again, Your Honor, considering all the information that was provided to you, considering the gravity of, his mental illness and his life, that you sentencing to what we recommended. And with that, I submit.
Thank you.
On behalf of Judge Holtis, Judge, the impact on me and my family has been substantial, both mentally and physically. The impact on my professional family has also been significant, both mentally and physically, especially in the case of my Marshal Shane, who suffered horrific injuries trying to protect me. To him, I am incredibly thankful and so very sorry. But for 6 men, grown men, half of whom were unarmed, I would not be here. To them, I owe my life and will forever be grateful. For years, the system has tried unsuccessfully to help the defendant conform his behavior and limit the danger he presents. Instead, his behavior has escalated to this: trying to kill me as I sat, just doing my job, in a courtroom surrounded by guards and court personnel. He made a conscious decision to kill me and made every effort to succeed. If he had his way, he'd be facing a sentence of life without the possibility of parole for murder. It is likely no surprise that for me, as well as his future victims who may not be as lucky, I wish for the maximum sentence allowed.
Thank you. Were there any other speakers?
No, we'll submit it, Judge.
Mr. Redden, I am not going to run any sentence that I impose today concurrent with that issued by Judge Holtis. In my view, you committed separate crimes, and that results in separate sentences. So it's not going to run concurrent to what she has previously issued as far as a sentence. All right. With respect to this sentence, first of all, there will be a $25 administrative assessment fee, a $3 DNA administrative fee. And Mr. Arnold, were you appointed or were you retained on this?
No, I actually did this case pro bono, Your Honor.
There will not be any DNA testing fee because frankly, given your history, it's already been taken. Your actions on that day, you know, it was not just retaliation for an attack upon Judge Holtis. It was also an attack on the judiciary. And I'm mindful of that. And while there is no question that you've got some mental illness issues, which is why you pled guilty but mentally ill. But there was no doubt by these doctors that you knew the difference between right and wrong, and you did what you did. So this is what I'm going to do with respect to the sentence. Okay, with respect to count one, sir, I'm going to do this. The minimum term that you would serve would be 8 years, and the maximum term will be 20 years. Plus, there will be a consecutive potential maximum term of 8 years to 20 years. So with respect to count one, the minimum term that you will be serving combined would be 16 years, and the maximum will be 40 years. With respect to count two, the minimum term that you will serve will be 4 years, and the maximum term will be 10 years. With respect to the consecutive enhancement, the age enhancement, the minimum that you will serve will be 4 years, and the maximum will be 10 years. So with respect to count two, the minimum term combined will be 8 years, and the maximum will be 20 years. The term that I impose with respect to count two will run concurrent to count one. With respect to count three, the minimum term that you will serve will be 2 years. The maximum term will be 5 years. That term will run consecutive to count one. With respect to count four, the minimum term that you will serve will be 4 years, and the maximum term will be 10 years. That also will run consecutive to counts 3 and counts 1. With respect to counts, well, wait a minute, yeah, okay. With respects to counts 6 and 7, sir, the minimum term in both of those counts will be 4 years. The maximum term will be 10 years. However, those will run concurrent to each other. right? So, I'm not following what your attorney has suggested, I'm following what the state has suggested. Did I catch them all?
I believe you skipped 5.
With 5?
Correct.
Sorry about that. Okay, the sentence with respect to count 5 will be a minimum term of 2 years, and the maximum will be 5 years. That will run consecutive to count 4.
And then counts 6 and 7 are concurrent to each other and concurrent to,
And consecutive to, well, wait a minute, that was, count 6 was with respect to Officer Brandon, right?
Officer Boo, you're on 6
Officer
and 7.
Boo, that will run consecutive to counts, the other counts. See if I can. Brittany,
Yes, ma'am.
did you get all those?
So, with respect to count 6, it's to run consecutive to counts 1, 2, 3, 4, and 5.
Right,
And then as far as count 7, it's to run concurrent to count 6.
correct.
Thank you.
Could you give me the aggregate, please?
Uh,
When you get a chance, and you need a second?
Yes.
you show 26 to 65.
I'm gonna verify. Well, that does sound about right, but let's verify.
And Your Honor, as to the restitution,
There will also be restitution to the victim.
thank you, Judge.
I still keep coming up with 36 on the top. Maybe it's 20. So here on count 1,
This, counts 1 and 2, that's 16.
yes.
That's 8. And then 8 goes into 16.
Yeah, so here I have the, and then you have the added 8 over 20. The average is 1640.
Right.
And then here you have, it's gonna run consecutive to the average.
Well, after this,
Yeah,
this will run,
concurrent. Oh, it's
Concurrent.
concurrent. I'm sorry,
Concurrent.
that's why.
okay.
Okay, so 26.
Yeah, count 2 will run concurrent to count 1.
So 26 on the bottom. And on the top, you have 40. How many months did you have on the bottom? 120?
We have 26 years to 65 years aggregate.
That looks about right.
Okay. And there will also be restitution to the victim, payable to the victim in the amount of $61,318.41, and that is CCMSI.
Yes, Your Honor.
And what does that stand for?
I don't know, I apologize, Your Honor.
Okay, could you do me a favor
I can
and
look
let
it
me know what that is? Because we need to put that in the judgment of conviction. And we need to give this gentleman credit for time served.
16 days.
60 days?
16.
16 days. Okay,
Thank you.
Thank you, Judge.
okay, thank you.
Right, we are on the record in the presence of the jury, State of Idaho versus Mark Jason Bent, CR 10-22-8186. Jury has been brought in. Mr. Neal, do you waive roll call of the jury?
Yes, sir.
Mr. Stavisky, do you will waive roll call of the jury?
Yes, sir.
All right. Ladies and gentlemen, good morning. Thank you for your patience this morning. As I indicated yesterday, I try and start on time, and most of the time it doesn't happen because it's my fault. We were having technical difficulties in the courtroom this morning, so I apologize.
Okay, today is, I don't even know what today is. Let's see, it's December the 3rd, Tuesday, December 3rd. The time is 8:45. This is the Committee on Parole, and we're in Baton Rouge right now. To my left is Carolyn Stapleton, who'll be serving all day today. And to my right is Danny Balrog. And my name is Steve Prater. I'll be the chairman for today. Like I said before, we're in Baton Rouge, Louisiana, at the headquarters, DLC headquarters. Staff, could y'all introduce yourselves, please?
Sherelle, big right. Carla Williams.
Okay, thank y'all very much. And the first case that we have today is Quinn Bryant, who is at St. Bernard Parish Prison. Is that you, Mr. Bryant, that I'm looking at on the TV?
Yes, sir.
Okay, and we're here for a revocation. And I need to know if, do you have a form in front of you that has your information on it?
Yes.
Okay, what is your DOC number?
766390.
Okay, and you signed this form, correct?
Yes, sir.
And that form is saying that you want a revocation hearing today and you're okay without an attorney and all of that business, correct?
Yes, sir.
Okay, well, let's jump right into it. Now, I know we've got two people that are going to be speaking on your behalf, and they are Natasha Morris and Sean Monica Morris, and they're going to be having Zoom calls, and you'll be able to see what they have to say also. But to begin with, let's just go over quickly what your charges are or what your violations are. Okay, you are accused of violating rule number 4, number 5, and number 10. Number 4 is criminal activity because you were caught with a gun and some marijuana. Number 5 says you can't be around guns, and one of the things that you had was a gun. And rule violation number 10 is that you owe $880 in fees. Now, you pled not guilty to the first two, but you pled guilty that you do owe some of the fees. Is all of that correct?
Yes, sir.
Okay, now you need to tell me when we talk about these rule violations, I said what you had pled, but I want to know do you want to make a statement about these?
All I gotta say is, I had no knowledge of no gun, you know.
Okay.
And like I, I plead guilty to the weed, but other than that, I did not know about no gun. I just, at the time of the accident, I spooked out, and I did not know what was in that bag, but the marijuana and the money did belong to me. I did throw the money and marijuana in the bag, but other than that, I did not know about no gun being in no bag. And I gave DNA swabble to the St. Bernard Parish, but it states in my summary that I refused DNA swab, but I gave DNA swab, and that's on record on Friday, August 23rd, 2024. It should be on camera and all. I did not refuse DNA swab.
Okay.
All right. But just to be sure, but for the record, you're saying that the marijuana and the gun, when you were arrested for that, the marijuana and the money that was in the bag was yours, and the gun was not yours. Am I saying that correctly?
Yes,
Okay, and that's your statement. And then as far as owing the money, do you owe the money?
yes, I do.
Okay, all right. Well, that's your statement. Next, we'll go into, we'll talk to Natasha Morris, who is your mother. Okay, is Natasha on the line?
Yes.
Yes.
Good morning, Ms. Morris. Would you tell us what you want to say in support of your son?
Good morning. I am Natasha Morris. And the day that the accident did happen, I was out with coworkers. They was having a celebration for one of our coworkers. We were out. We had a couple of drinks and stuff. So in the midst of having the drinks, I was ready to go because I felt like I had done had enough. I called for my daughter to come pick me up. She was unable to come pick me up because my grandkids were asleep. So Quinn was over here at the house. She told Quinn, she was like, Quinn, can you go pick mama up? My car was here. I do carry my firearm. I'm a 50-year-old woman. I do carry my firearm for safety. That's it. I carry it for safety only. In the midst of him coming pick me up, he picked me up from the club. I believe he was at round 2. Picked me up from there, brought me home. When I did get home, not realizing I did leave my bag in the car with my firearm. It's my firearm. In the midst of that, I tried calling my daughter. I'm like, Shamanika, I don't want Quinn to touch it because I don't want him to know it's in the car. When he get back to your house, can you please go in the car and get my bag out the car and put it up? He was using my car to come out to the Shelmet to come by my daughter, get his hair done, and to go see his newborn baby. So I do feel at fault for that because it is my firearm. And I just feel like I'm the fault for it all.
Okay. All right. Well, thank you for that statement. And does anyone have any questions for release? Okay. Okay, next we'll hear from, and I may say this name wrong. I'm gonna give it a shot. Shamanika Morris.
Great job. Yes. Yes, I'm Shamanika Morris.
Okay.
Yeah, I'm Quinn's older sister. I am the daughter that she called to come and pick her up that night. I'm just here to basically say that, I got the call for her to come and pick me up, and I asked Quinn to come and, to do it because I have little babies and I didn't want to leave out the door with them. So Quinn, his new baby was just born maybe the same month, and he was supposed to be going to see the baby that night. So on his way out here, she did say that he should drop it off to me.
Okay. All right. Well, thank you for that statement. We appreciate that. Any questions for the panel to her? Okay. Being none, the way we do these cases, we all study them very hard. And then one person leads in the questioning. And this particular case, we have Danny Barra. Excuse me, I have trouble with that name. Danny Barra, yeah, North Louisiana. So, and so, Danny, you'll lead the question if you don't mind, and start us out. We'll see where we go from there.
Well, there's not too many questions because you pretty much answered them all already. You did plead guilty to the marijuana that was in the bag, but the gun, you're saying you don't know nothing about it. So that kind of, that's your story, I guess. The probable cause was found at the preliminary hearing by the panel of probation and parole officers, and based on the body cam videos from the police department showing that they took the gun out of the car that you were driving. That doesn't look too good for you. But as far as questions, no, I don't have any questions.
Okay, Ms. Stepman? No. No questions? Okay, let me ask this. How much marijuana was in the bag?
About 15 grams.
And how was it packaged?
I believe 3 grams a piece.
It was 3 grams per bag, is it?
Yes, but
it states that it had 7 bags of marijuana, but on body cam footage, it was only 5 packages of weed that was found in the bag.
Okay, was there cash in the bag too?
Yes.
How much cash?
I believe $210.
Okay, that could have gone away toward paying what you owe as far as court costs and fees, couldn't it?
Right.
Okay, I think I don't have any more questions. I know what's going on, believe.
All right, we're ready to vote.
We're ready to vote now, and it takes the 2 out of 3. In other words, if 2 people vote not to revoke you, you're not revoked. So you got to have the majority of it. So we'll start out, Mr. Barhoff.
Yeah. So you already pled guilty to the charge. So you're convicted of a charge while you're on parole supervision. The parole officers are recommending revocation. And I find it hard to believe that you couldn't tell the weight of that bag didn't have something else in it besides that marijuana. So for those reasons, I got to vote to revoke your parole.
Ms. Stapleton?
And I concur with Mr. Barra. I don't have anything to add or take away.
Okay, and I concur also. So your parole is hereby today revoked, and that's the end of this hearing. Thank you. Signing off from St. Bernard.
Yeah.
Hey, my name is Steve Prater. I'm the acting chairman today. To my right is Danny Barra. To my left is Carolyn Stapleton. And we're here, the Louisiana Committee on Parole is met this morning. We've already had one case before We've already had staff introductions and all. So we'll be going now to LCIW, and we'll be taking the case of Kimberly Loss. Am I saying that, Miss Kimberly?
I think it didn't happen.
Okay. Yeah.
Yes, ma'am. Can you give us 1 second?
Sure.
He just got word that you all ready for us.
Okay.
Yes, sir. Thank you.
You're welcome.
Yes, ma'am. We're ready for you. I know.
Okay, we'll, for the purposes of telling you about us, Kimberly, we'll start over. My name is Steve Prater. I'm the acting chairman today. To my right is Danny Barra, and to my left is Carolyn Stapleton. And we are here to talk about your case and find out just exactly why you think that you're worthy of being paroled today. We're at headquarters in Baton Rouge. There's a number of people here. And before we have the staff and the folks there introduce themselves, let me just tell you who is here so that you will know. Let's see. We have Gary Myers, who's going to be on Zoom with us. We have Christy Sheremy, Carol Adams, Demetrius C. Moore, Stephanie King, and Sierra Del Garza. Of course, I think Sierra is there. But the others are here at headquarters seated, and they'll have a chance to talk. And I apologize for any names that I got wrong. In opposition will be Randall Meyer, and Haley Ravebane. And they are both, or Haley is here at headquarters, and Randall will be Zooming with us, I'm sure. And so that's kind of the setup for today. Before the board gets into any questions, we'll hear the folks that are going to speak for you, and we'll hear the folks against you. But first, before we do anything, I want the staff there to introduce themselves, and we appreciate you and the hard work that y'all do. Would the staff introduce themselves?
Yes, sir. Good morning. Kristen Thomas, Warden.
Good morning, Tara Pete, ARDC Manager. Acting Gaddy, ARDC Supervisor. Lieutenant Williams, Active Security.
Okay, thank you. Appreciate you accommodating us this morning. And what about the rest of the folks that are there? Would you introduce yourselves? Kimberly, would you tell us who's there?
I can do it. Yeah, I'll do mine.
Okay.
Good morning, board. Adrienne Hutchison, attorney for the Louisiana Parole Project, here on behalf of Miss Kimberly Law. And when the board deems it appropriate, I'll make my remarks.
Okay, thank you.
I'm Heather Bridge. I'm Kimberly's sister.
I'm Lawrence Lawpack, Kimberly's dad.
Okay, welcome, and we appreciate y'all being there and helping us with what we have to do this morning. Okay, we've got the staff here that's already introduced themselves with our first case. You know who the board is. We know everybody in the room here, and we know everybody in the room there. And so now it's time for you, Kimberly. Tell us, to get us started here, tell us exactly why you feel like you're worthy of being paroled.
Well, first of all, let me just start by saying, I've struggled with that my entire prison sentence of why I would be worthy to be here today. I caused a great deal of harm to many people, and I have struggled with that. But the person that you have in your file in front of you is not the person I am today. I've prided myself in my sobriety and educating myself to be the best person I can be for the rest of my life, sir. I make it my goal every morning to remind myself what my sobriety has got me and how far it has gotten me. Because there wasn't a minute when I was on those streets that a minute went by, a second went by, an hour that didn't go by that I didn't need to be high to cope or to just cope, sir. But I'm not that person anymore.
Okay.
A lot of help from staff here, classes. I'm no longer that person. And I feel like I can do everything possible through my two-lane degree. I would like to become a social worker to help young girls like me, never to be like me, or to cause the trauma that I caused to anyone else, and the pain and the hurt and everything that they've had to live with.
All right. I appreciate your statement, and I can see the remorse in your tone and what you're saying. So we'll continue now, and let's see. Adrienne, we'll let you be last, if that's okay with you, and we'll take next. We'll take let's see. Let's leave Carrie second, and Heather, why don't you go ahead and tell us what you have to say, Heather?
You can step up.
Oh, okay.
Stay right there. Thank you. Sorry, I have to have glasses because I've made 51 and eyes don't work like they used to. So first of all, thank y'all for letting me come on behalf of my younger sister, Kim. Really, her name is Kimberly, but I don't think I've called her Kimberly unless I fussed at her when she was 6 anymore. So otherwise, I just give her eyes and she knows that her ass is mine, pardon my French, or English, and how you'd like to look at that. Ever since she has grown up, she has been that little sister. We were inseparable. Even though there's a 7.5-year age gap, I will say I look younger than she. She started out as my living little doll She graduated to being my model and then my best friend. Has always been caring, loving, giggling. That giggling one that just had the knack for when she saw anybody else in the world, whether it be in the grocery, a family gathering, or whatever, just needed a hug. And at 3 years old, she'd walk away and go see that person and offer that hug. As we began to age, Kim became our constant performer, very creative. And as women, we became one, especially when she became a mom first. During those long distance times, we had to pay attention to our minutes so we didn't go over our allotted budget for the month. We watched the minutes to save money, but planned our next visit in person. Just from Mississippi to Louisiana, it seemed like a far distance. God knows it was only 50 miles at best, but those minutes would add up. Once I became a mom, Kim became my Bible of what to do because she got there before I did. The calls, the in-person visits, we kept each other going. Eventually, she had another child, and her life became a little bit of a struggle. Her relationship with her children, and the children's dad, I should say, became a little strained, and Kim felt that she didn't have the right skills to properly handle and come out on the other side stronger. Sorry. Due to some upbringing and our different upbringings, she could not thrive when the devil was tapping in. I believe for her at that time, it was easier to open the door than to fight to close it. Which leads me to a path of choices that aren't pretty. Kim was an easy target to drugs, alcohol, physical, and emotional abuse that she did sustain from the kid's father. We then all tried to stop, get in, and become a part of a helpful system, but Kim felt the love for her kids and their dad was more important than stopping for herself. Unfortunately, I'm going to jump to where we became a part of the prison system. As a family, we became a part of the system.
I didn't say this before we got started, but we really need to limit our remarks because we have a lot of people will be talking in this case.
Okay.
If you would, give us the gist of what you have to say, please, ma'am. I know you've got some remarks, but
Kim has done nothing but becoming a remarkable person after she submitted to what was a true problem in her life, which was drugs and alcohol, and allowing those to step in and overrun her. Once she gave into that and realized that that destroyed her family, all of us, she then decided, let's get a GED. Let's see how I do. Then asked, hey, you think I could do college courses? Hey, do you think I could do this? And then the less confidence became more confidence. It never became, do you think I can? It has now become, I've done it and I'm going to continue doing it. And if I do this course, I'm already looking into what the next ones are. Kim's decided that her future is on a path that's godly, that's family driven. Her demons will always be there, but she's decided to fight for them, her family, and herself.
okay. Thank you very much. Thank you for those remarks. Now, everything you said was meaningful and taken to heart. And I'm sorry to cut you off a little bit, but anyway, it was necessary. Okay, let's hear from Carrie Myers. Carrie, would you tell us what's on your mind?
Good morning, Kerry Myers, Louisiana Parole Project. We're here to let the board know that we have full support of Kimberly should this board grant her today. Kimberly impressed us tremendously by her commitment to her sobriety, by her work ethic. She works at DOC headquarters, which is a highly trusted position. She is thought highly of by staff. She has earned an associate's degree currently in a bachelor's degree program with Tulane. She has trained service dogs for veterans. She is a regular participant in AA-NA and continues to work on her sobriety. She's a certified sign language interpreter. She's done nothing but her trajectory is just continues to move upward. And we think that Kimberly is not only destined for success, but we are fully committed to helping her reach that success should this board grant her parole today. The fact that she's overcome the adversity from her childhood to become who she is today is like I said, is extraordinarily impressive. Someone who has dealt with trauma, the terrible effects that trauma can cause, and has come out the other side and continues to excel. And so should she be released today, granted today, she'll come to Parole Project, where she will have a mentor who will guide her through this process. She will have the full resources of our program as far as housing, employment opportunities, and all the other resources that we can provide for her. We've already evaluated her. Our social worker has already evaluated her. And our recommendation is a long-term outpatient continued sobriety program, which she is absolutely willing to participate in. And we would just ask this board to consider Kimberly's long, hard road to where she is now, the work she's done and the trajectory she is on, and grant her parole today.
Okay. Thank you very much for those comments. All right, now we will hear from the attorney for the Louisiana Parole Project. Ms. Hutchison, would you want to talk to us now?
I believe there's one more speaker. It's Ms. Stephanie King should be present at the board.
We just have three that we don't normally have three and the attorney. Sorry, that was my mistake. We do have three speakers and then the attorney. Okay. Yes, ma'am. It's your turn if you would like to speak. Introduce yourself once you get up there. Even though I've introduced you before, talk about this one over here is fine.
My name is Stephanie King. Some of this board may know me and remember me, and some of you may not. I too was once at LCIW with Kimberly. I served 27 and a half years of a 60-year sentence before this committee saw in me what I hope you see in Kimberly today. Like Kimberly, I too came from a troubled past, and like Kimberly, I used my time at LCIW wisely to rehabilitate myself, get educated, grow. I remember when Kimberly came to LCIW, she was young, confused, and full of grief. But our close-knit family of women took her in and helped her find her way. The turn she has taken has been dramatic and inspiring. She immediately got involved in things once she arrived, taking programs, joining clubs, going to school, and spending quality time with her family during visits. Our schedules in prison can be busy, and so to be able to work your full-time job, mentor or help others, fulfill your obligations to your clubs, and then work on the course load from Tulane University is far from easy. And Kimberly is doing it and doing it well. Today, she has a community that she never had before she went to prison. The women you see with me are all formerly incarcerated women who have been with Kimberly along the way. We are here to let you know that we are still here to support her as we supported each other in prison. She is not alone. She is loved, and all of us intend to support her if you need so. Today, she has a community of Tulane professors and Operation Restoration staff here that should have been on Zoom to support her, who are proud of her and ready to help on this side. And just as they have helped me, I think y'all got letters from. And today, I pray that you see how far Kimberly has grown and all the things she has done to better herself while incarcerated. I pray you see how she has truly transformed her life and become a whole new woman. And I pray that you give her the opportunity to walk across the Tulane stage at graduation with all the other Tulane graduates, all of us formerly incarcerated. Thank you.
Thank you for the comment. Appreciate it. Okay, I think I'm back on track now. Ms. Hutchinson, I believe it's your turn to speak, and I could be wrong, so feel free to correct me.
No, sir, Mr. Prater, you're correct. Thank you for having me today, board. I think today we have the opportunity to see true rehabilitation and change. Nothing Kimberly or I will say today will or can change the facts of the crime. Her remorse, the grief, and trauma of her actions are a part of her DNA now. I think you can see that. She lives with the facts and all of the effects of her crime every minute of every day. The death of her baby boy and the loss of Haley and Bradley, her two older children, showed her how deep and dark her addiction had taken her. Over the last 20 years, she's pulled herself out of that deep and dark hole. I think a lot of what I was going to talk about has already been said, but I do want to hit on just a few extra things. We talk about her education, but Kimberly's education, she had only gone to the 6th grade by the time this crime happened, even though she was 24 years old. She's now completed a literacy program, obtained her GED. She can be a sign language interpreter for public settings. She's certified. She's a student at Tulane University, but I want the board to understand that they have to go through the same requirements of anybody who goes into Tulane University. That goes to the School of Professional Achievement. And I didn't tell Kimberly before this, but if you look into the exhibit of the letters from the director of the Tulane program, Kimberly is on track to graduate summa cum laude. That's the highest academic distinction you could get in college. That's a far cry from the young woman who committed this crime. Tulane University and works directly with Operation Restoration in the brief, and also in their letters, they discuss that they continue to support these clients once they're on the other side. I know when you look at Kimberly's background, you'll understand that somebody with that amount of trauma needs a large level of support. And while I know you have us with Louisiana Parole Project here, Operation Restoration is here, Rise Collective is here, all support, and Tulane University, all here to support her if she is granted release. Her service to others is probably the most I've seen, or one of the most I've seen over the time that I've been doing this. Training service dogs for wounded warrior or parents who need service dogs for children with disabilities. And one thing that she'll talk about when you speak with her is that none of this was possible without her sobriety. As people wake up in the morning and read their daily devotional, Kim wakes up and reads her AA manual. This is something she knows that she has to have every day to continue to be successful. The people that you see there, the people in this room, and all the people that wrote letters are here for Kimberly's support in reentry into society. Her ability to be with LPP long-term allows us to maintain and manage her sobriety and continue her with any type of additional services that she needs through our social worker. Additionally, if this board deems that Kimberly needs anything additional while in prison, her parole eligibility date is not until August of next year. So any classes or courses that you may want her to take between now and then, she would have the time to take them. I just really hope that this board sees that Kimberly has done an amazing job going from the person she was 20 years ago. And she's a person that she never even could see to be today. And if this board has any questions or concerns, I'll be more than happy to help with any of those questions. And I would just reserve the right to clear up anything at the end of the hearing, if necessary.
Okay, thank you. And Warden, we'll get to you in just a little bit. I'll be asking as soon as the opposition to parole has their say, then I'd like to come back to you and your staff and hear what y'all say about her before we do our questions. So
Yes, sir. Thank you.
just so you can be prepared for that. Okay, we'll move to the opposition. We have Randall Meyer, and we'll take him last, and Haley Raven. Okay, Haley, it's your turn, and if you would approach the podium and speak to us for about 3 minutes and let us know what you think.
Coming from one of her and only daughter, she took a life of my brother. She took a life of mine. She left me in the hands of a very abusive home. She put me into a sexual assault situation. She took the motherhood that I wanted growing up. She took it from me. I never got to meet her. I never got to experience a motherhood from her. Coming at 24 years old now with my own daughter, I could never imagine taking a life of a newborn. I will always stand on this. I don't think and will never think she deserves to ever know me or my daughter, and I take that hardly. This is not my only court case I've ever gone through, and this is a closure that I needed, and that is why I'm standing here today. I don't think she deserves to walk the streets that a little boy should have been able to walk, and he wasn't able to. He took his first breath, and that was it. He got to experience life in a dumpster, and I don't think anybody deserves that. And honestly, I think she needs to deserve the rest of her sentence, just like he didn't get to deserve a life. And that's all I'm gonna have to say today, sir. My opinion is what it can be, but I don't ever want to have any connection with her, and I don't think she deserves anything.
Thank you for those words. We appreciate that. Okay, Randall Meyer, would you please let us know what your feelings are?
Yes, sir. Randall Meyer, Assistant DA, Jefferson Parish. But with all due respect, I'd like to hear what the warden has to say before I comment.
Okay. All right.
We always feel that the warden has more contact with the victim with the inmate than any of us, and I like to hear their position on things.
Okay, I think that'd be appropriate. Warden, would you go ahead and tell us what's on your mind then?
Yes, sir. Some of the notes that I had made prior to this are kind of a repeat from what some of the people that spoke in support of Kimberly, but she is a minimum custody inmate, and she does work at our headquarters office every day. So she is trusted, and all of her work supervisors at headquarters have given her glowing remarks, and she really puts all that she has. When she does come back, she lives in the dorm where we house some of our new intakes and our reentry offenders. So while she's not here during the day with those inmates every day, but she is mentoring them when she comes back in the evening, whether that be just because they're new into the system and to try and guide them to follow the right way and follow the right path, or whether it's about sobriety and getting people really on that path to wanting to be where she is and to achieve what she's done. She is very serious about her educational studies and really puts a focus on that. I think, Kimberly and I spoke last week for a little bit, and, she said she just feels like she really has put forth the effort and just feels like she's in a really good place right now. But again, I've never had any issues with Kimberly. She's always done anything that's ever been asked of her. And I do think with the family support that she has here with us today and with the Supportive Parole Project, I think she has a good head on her shoulders right now.
Okay, thank you, Warden. We appreciate that input and value what you have to say. All right, Mr. Meyer, I think it's your turn now.
Yes, sir. Thank you, Randall Meyer, Assistant DA, Jefferson Parish. We submitted a letter in opposition to Ms. Loft, and that was based on the victim opposition and the nature of the offense. And also, I note that she's only served about half of her sentence. it sounds like Ms. Loft has done a lot of good things. If this board were to decide to grant her parole, we would recommend that she, be ordered to complete a long-term substance abuse treatment program, as Mr. Myers had pointed out that they had ready to help her with, and also that there be some mandated AA and NA continued attendance at meetings for AA and NA. I've not necessarily sure y'all have heard this from me before, but I've got a good friend who's been 40 years involved in AA, NA. In fact, he told me not long ago that the first event he attended sober was my wedding. 40 years ago, and he's still very involved in it. He still goes weekly. He still sponsors people. So I think it's a extremely important program, and for her to continue with when she ever does get out, and while she remains incarcerated. So that's our position today. Thank you.
We thank you for your remarks. Thank you very much, sir. Okay, the way that we do these, as far as the process goes, is that we've heard a lot of input from both sides and from those that are not really on a side. And now the board has studied this. We've had weeks to study it, and we've all made ourselves very familiar with it. But we divide these up, and one leads the question and votes first. And Danny Barha,
You got it, Barra.
much as I know him, I still can't say his name. So if I offended anybody's names today, then it's just me. But Danny, would you start the questioning for us, and then we'll see where we go?
Yeah. Before I start the questioning, I just put a few things that on the record, a little details of the crime, a little bit of the stuff I saw through the paperwork, and basically on November 8, 2003, a newborn male infant was found in a garbage can with the placenta after birth. Through investigation, the mother, Kimberly Loft, was interviewed at the hospital where she sought treatment. She admitted giving birth to an infant who was stillborn. She admitted concealing the pregnancy by wrapping the infant in a towel and putting the infant in the garbage can. On 11/10, forensic pathologist ruled the infant's death was a homicide. Loft was questioned a second time and admitted the infant was alive at birth, and she wrapped the infant in a towel and concealed the birth and placed the infant in the trash. I also see through looking at the file that you're a true first offender, which is good, that you haven't had any write-ups since 2015. That's also good. You served 21 or 40 years. You do have law enforcement opposition and opposition from family. So those things being said, my question is, can you explain to me your state of mind at the time of the crime? What caused you to do something like this? I can't even wrap my head around it. I just would like for you to explain to me a little bit of how things could go so bad.
The only way I could put it is, sir, I was an addict and I panicked. And that is a panic that I have lived with since. There are no words that could put a reason to what I did, sir. There are no words other than I was a coward. And that's all I've looked at myself as a coward. I live every day, sir, with what I did, with the lies I told. I live with that every day, sir. There is no words for what I did, because it is unexplainable. There are none. There are none. And I know how it looks, because it wakes me up at night. I know how it looks. I ask myself daily, how could I have been such a damn fool? But I have no answers even for myself, sir. And I can't change what I did. I can't. I'll never be able to change it. If the board was to grant me today my freedom, I would only be free from prison, sir. I wouldn't be free from my actions. I wouldn't be free of abandoning my children. I won't be free of none of that. So no, sir, there is no words that could justify my actions, sir. Other than I was an addict and I was a coward.
All right. What are your plans like? Should we release you? What's your plans for the next 5 years?
Well, I would like to go to parole project for as long as possible. I would like to finish my bachelor's degree. My main goal is to be a social worker. I would like to reach out to young kids who feel like they have no one to turn to, sir. I know I did a horrible job with my children, and to hear how I hurt my daughter, I can't change that, sir. I can't. There's nothing I could do in this prison that'll change that. There's no class. There's nothing I could do to change that. But there is somebody that I can help out there. I know there is. I know there is. And that is what I strive for. That's what my sobriety strives for. That is what my everyday strives for. As everyone has told you, I spend my days working in headquarters, and by night I'm either in school, helping a mentee with homework. There's never a moment that goes by that I'm not giving back to my community, considering everything I took and everybody I've hurt. All of my pain, that's my driving force, sir, to stay sober and to become a social worker. It's my driving force, sir.
Thank you.
Okay.
That's all the questions I had.
Yeah, how old were your two children, when this happened and you went to prison? How old were those children?
I think they were like 5 and 3 at the time.
So the girl who spoke here today, was she your 3-year-old or your 5-year-old?
Yes, ma'am. My 3-year-old.
Did they go into foster care? Is there where the children went?
No, ma'am. Actually, they stayed with my parents until their father asked me to hand over custody to them because he felt like they needed to be together with him. That is the only reason why I sent them to live with their father. Only reason. Other than that, they would have stayed in the hands of my parents, and my sister was willing to help in their care. Haley was in school at the time of this incident. While they were in my parents' care, they came to Caring Parents on the compound. I still had access to my children. The day their father asked me to sign them kids over was the last time I saw them.
Yeah, because I heard your daughter saying that she lived in an abusive home. So I'm assuming that happened when she was handed over to her mom.
Yes, ma'am. She was very taken care of at my parents' home. She was in Hazel Park Elementary until Hurricane Katrina. After Hurricane Katrina and they had to relocate, my parents immediately got her back in school.
Yes.
They had the best of care with my parents. My parents loved them. And if hindsight's 2020, if I would have known 20 years ago, giving that girl to her father, this was going to happen, she would have gone in foster care before she'd have ever went to him. What I did and the reason I'm here today holds nothing on my children.
No. Well, let me ask you this. You say that you want to be a social worker.
Yes, ma'am.
You want to do outreach to children. So if you were to speak to a crowd, how would you start your presentation?
I think I would introduce myself as an addict.
Okay.
Because that is how I introduce myself today. When we get new commits in here, I introduce myself as an addict and they just look at me and they ask me how long I've been in jail. And I tell them how long I've been in jail and they always wonder why I still claim myself as an addict. Because ma'am, there's one thing I've learned. You can stop being an addict, but you will always be an addict.
Okay, well, my second question is this. What put you in jail? When did you bring up the subject of you put your baby in a trash can and let it die? In a crowd of people, when do you say that? In your outreach?
Immediately. I want them to know where I come from.
Because I know you said you're going to tell them you're an addict, but the second part of that is
Immediately. I'm an addict and this is what I did.
Sure.
Immediately. I had to spend all this time. I can't run from it, ma'am. I can't.
that's the harder thing in life when you
Yes,
get
ma'am.
out, be
Yes,
able to say. Because, we all live with our truths at a lot of times. I mean, a lot less than that we don't like to share with other people. So that would be very difficult. So I was just wondering, as a social worker and to have outreach, what would be your topic? So that's the only question I've got.
Okay. All right, I don't have any questions. Thank you. Are you prepared to vote?
Yes. Let's have an executive session.
Okay, we have a motion for an executive session. Do we have a second?
Second.
Okay, staff, would you call the roll, please?
Carolyn Stevenson,
Yes.
Steve Prayer,
Yes.
Danny Virus.
Yes.
Okay, we'll be in an executive session for just a very few minutes in the back, and we'll come back out and we'll take our votes and let you know what the outcome is, okay? All right. Okay, we'll have a motion to come back from executive session to the regular session.
Yes.
Stevenson,
Yes.
Prayer.
Yes, yes. Okay, we'll resume at 9:45. I don't think I gave the time when we left, but it will be easy to figure out at about 9:42. So we'll say that. And anyway, it's time to vote now. And so, Danny, would you give us your vote, please, sir?
All right. Today, I'm gonna vote to grant you parole based on you being a true first offender, you having a good plan with the parole project, the numerous letters of support, the accomplishments that you've made in prison. However, I'm gonna add special conditions to your release that you stay with Parole Project at least 2 years, that you complete weekly substance abuse classes, that you do monthly mental health classes, all of those monitored by Parole Project, and you follow all recommendations for treatment and services. And that's my vote.
Okay, Ms. Stapleton?
My vote is, I concur with Mr. Barra, but I do want to acknowledge the pain that Haley has suffered. And I'm so glad she had the courage to come speak to us today, because this has been a devastating event for everybody, as we know. And so I do concur with Mr. Barra, and my vote is going to be Grant also for the very same reasons. But everybody's pain is coming from a different place, and it all matters.
All right, that's 2, and it takes 3. So my vote's gonna be to Grant too. That's not normally like me. The reason I say that is I'm usually a tough sell. I don't know what more we could ask you to do. I know how hard it's been on you, and I take what the warden has to say very much to heart. And so with the conditions that Mr. Dan put on you, my vote is to grant also with the same acknowledgement to the opposition. So that's the end of this hearing. The time is 9:47. Signing off from LCID.
Thank
you.
All right, this is the Louisiana Parole Board that's meeting, and we're here to talk about a revocation that's coming up from Jefferson Parish. So Jefferson Parish, would you introduce the staff there, and is Mr. Kelly Johnson there?
Yes, he is. My name is Deputy Marlboro with Jefferson Parish Sheriff's Office.
Okay.
And I got Kelly Johnson. Have a seat.
Thank you for hosting us. Okay, Kelly, good. I'm glad that you're there. Okay, do you have, in front of you, do you have a sheet of paper that, okay, and on that sheet, what is your DOC number?
45 95 92.
Okay, and you got your sheet of paper on there saying what you've been accused of and everything that you, but would you go ahead and tell us right now, what happened and why, tell us how you plead on these different charges that you've been, charged with.
I was charged with a traffic stop and a possession of marijuana. I had pled guilty to that, and they gave me 60 days credit for time served. The domestic charge, ain't nothing happened. It was just an intense argument, and she threatened me, saying she was gonna call the police, and that's what she did. But ain't nothing happened physically. And as far as the car, I was going through a mental breakdown, and I used my friend car without his permission.
Okay.
And all the charges was dismissed in the courtroom.
Okay, the charges I meant were really rule violations. So let me read those to you and see what you say if you're guilty or not guilty of it. Okay.
Yes, sir.
I will not engage in any criminal activity or associate with people who are known to be involved in criminal activity. I'll avoid bars and casinos. I'll refrain from the illegal use of drugs or alcohol. And you were arrested and charged with domestic abuse with a child present, criminal damage to property, and motor vehicle theft. Now, how do you plead to those?
Not guilty.
Okay, so you weren't guilty of any of those charges of criminal behavior. Is that what you're pleading?
Yes, sir.
Okay, thank you. Okay, wasn't listed there, I don't think, was it? I was reading from here. Oh, I didn't see that sheet. Okay. Also on number 4, you pled guilty to possession of marijuana. That is a criminal violation, though. How do you plead on that?
I have pleaded guilty. I got 60 days credit for time served for that.
Okay, so the rest of number 4, the other charges, you pled not guilty on. They were ultimately dropped.
Yes, sir.
Possession of marijuana, you did plead guilty to, and you got sentenced to something on that, correct?
Yes, sir.
Okay, let's look at number 6. You failed to provide proof of employment since the time that you lost your job at Jaeger's Seafood. Guilty or not guilty?
I was guilty that I was going through, like I said, I'm going through mental breakdown, trying to reestablish myself. And I got hired at Kentucky. I just forgot to report it.
Okay. And you failed to make any payments towards your supervision fee, and you owe now $252 is what you owe right now. Is that correct?
Correct. Because when I like I said, when I lost my job, it took me a little while to get the next job, and I forgot to report. And I'm trying to reestablish myself. So it was just a minor mistake.
Okay. All right. Well, Mr. Johnson, Mr. Danny Barra is the lead on this particular question and figure out exactly what you're doing and what we're going to do with you as far as revoking your parole or not. So, Mr. Barra, would you start out the question, please?
I had a question about the motor vehicle theft. You at the preliminary hearing with the probation officers that went meet you in jail, you pled guilty to that at that time, and you stated that you did not have any recollection of this incident, so you must be guilty. You stated you were going through a mental breakdown and was under the influence of methamphetamine. The agent provided a police report indicating that these charges were refused by the district attorney's office. So you pled guilty at the preliminary hearing before the charges were dismissed. I'm just wondering
The charge was already dismissed, and he just asked me what happened. I told him I couldn't remember exactly, but when he read it to me, I kind of remembered. So that's why I said I must be guilty. But overall, I was not charged with it because they refused the charges.
Well, the preliminary hearing was held on August the 9th. The charges wasn't dismissed. Okay, the charges were dismissed on August 30th. So you pled guilty before the charges got dismissed. All right. I don't really have any other questions. It looks like you have violated several of the conditions of your probation, and they found probable cause on all of them at the preliminary hearing. And the parole officer who supervises your case is recommending revocation of parole.
Okay. And I'll give you another chance to ask a question, but I failed to call on the sister who did want to speak. And so I apologize for that. Is Christina Tazinio, is she
Yes.
on Zoom? I didn't see her picture.
That's my older sister.
Is she on Zoom?
I don't see her.
She is?
She's on county law.
Okay. Christina, are you on? Can you hear me?
Yes,
Okay. Do you have something that you'd like to say about your brother?
like he was saying about the incident that happened, he wasn't aware of what was really going on at that time. Like he said, he just came out of the mental hospital. So he was trying to correct himself, like he's saying. And by him being on the methamphetamines, whatever he was on, to my knowledge, that's why he don't remember what happened. Like he said, it was a friend's car that he drove, not even that far away, but he did get out the car and he did get the car back. So I understand why he's saying they dropped the charges, because they did not want to press charges on him at the scene of the accident.
Okay. All right.
By him working, he was just starting his new job. So I assume he was trying to, still work at the same time of still being treated at the facility he was turned himself into, because he knew he wasn't in his right mind, like, with all the things that's going on in his life.
Okay. All right. Thank you, Christina. And Lenore Baker is on a Zoom call also. She is not going to speak, just so that you'll know your other sister, another sister is there also. Okay. I'd already asked Mr. Danny to say any questions he had. Do you have any more questions from that? Just open.
Well, I've got, on the police report statement, it says that, you and your girlfriend, that you share a 2-year-old daughter together, and that y'all got into a verbal argument, and that with your closed fist, you shattered the women, striking Miss Lane. And, the 2-year-old daughter was present at the time. And you were charged with domestic abuse battery on that with child endangerment. That was a charge that you did get. And also in her statement, she said you've done this before to her. Now, no doubt about it, it might be a volatile relationship between yourself and Miss Lane, but still in all, you were charged with that also, which is a violation. A very dangerous violation. And then you were using meth. You admit to using meth, and that you said that's how this happened. And the policeman, the police person there saw the swelling on the right eye. So there's definitely probable cause for that one also.
She was speaking out of anger, and that never took place. She said all that out of anger. I never hit her. I never shattered the windows, nothing. And none of that never happened. It was just an intense argument. That's it. My child wasn't even present.
Well, policeman was there. So the child's present.
Probably at the scene when she called the police at. It happened in front of my mama's house. It was just an intense argument. And she left telling me she's gonna call the police on me and put me in jail because she knew I was on parole.
Okay, I don't have any other questions.
Okay, I don't have any questions. Are you prepared to vote?
Yes.
Okay.
All right, I'm gonna have to vote to revoke your parole based on the continued drug use while on parole supervision and continued criminal behavior. You pled guilty to the marijuana charge. You admitted you were on meth and you was already on supervision for meth. It just shows us that you're not interested in being on parole if you're gonna continue to violate all those conditions.
I'm not. I'm being honest about it. I needed help. I admitted myself in the hospital. I was trying to do better. I was going through things. I got put out one house trying to correct myself, and I had to move in with my mama. I had to find another job. It was just overbearing. I ain't really had too much support. I did everything I could to my best ability. I'm just asking for another chance. It was a simple mistake in arguments.
Okay.
Okay, well, you're gonna always be going through things. We all do, but not everybody has that as a fallback guy. So I concur with Mr. Barr.
And I concur also. As of today, your parole has been revoked for the continued drug use and criminal behavior that you've continued in since getting out. Being on parole is the time that we take to see if you're willing to abide by the rules and laws that everyone else has to abide by. And it's apparent that at this stage of your life, you're not ready to. And so next time you get out on parole, I would suggest that you try even harder. That's the end of today's hearing. It's 10 o'clock. We're through at Jefferson Parish.
That's crazy.
Hey, that's all you need?
Yeah.
Okay.
So when you come on, it's gonna be great.
Okay, you ready for them? Okay.
You want?
No.
Mine's, this who?
Oh, no.
Mine's next. They probably took the guard off. I'm about to tell them the guard is here, because we told them he's there. Yeah.
Thanks for the wrong information.
Yeah, so mine's, this is the next person.
So, all right, should we leave the guard right here or should we go on to mine?
Mine, yeah.
Okay.
This is, yeah, he's next.
All right.
Okay, there we go. Nope. There.
Hi. Good morning.
I like that with the blurred background. Good morning. How are you today?
Good.
Okay. Mr. Montz, is that you? Can you hear me, Mr. Montz?
Yes, sir. It's a little loud. I can turn it down a little bit.
Okay.
Okay.
Okay. All right. Well, my name is Steve Prater. I'm the acting chairman for today. To my right is Danny Barra, and to my left is Carolyn Stapleton. And we're here to hear your case about and make a decision on whether to revoke you or not. I understand that you're at the Orleans Parish Prison. Is that correct? Okay. And you have a piece of paper in front of you. Would you read your DOC number off of that, please?
My DOC number is 131744.
Okay. And you understand all your rights as far as this hearing goes, and you've signed a piece of paper. Is that correct?
Sure, yes, I did.
Okay. And do you have an attorney for this, for our hearing for today?
Yes, I do, sir.
Okay. And I think they're with us on Zoom. And we have two, and I apologize before I even try it, Michael and Joseph Responti. Did I say that halfway correctly?
Yes.
Okay. And they are on Zoom with us, and they will have a chance to speak in just a few minutes. Okay. But I want to find out from you today, right now, is your plea on certain rule violations. You know, when you have a parole revocation hearing, there's certain rules that you have to be charged with, and we want to hear what you have to say, so you can say that you plead guilty or plead not guilty, and then you can give us a statement about whether you plead guilty or not. Okay, so I'm gonna read these. It's real simple. The first one is that you violated rule number 4. That says you won't engage in criminal activity or be around guns or anything like that. And it says on September the 3rd of 2023, you engaged in criminal activity when you committed the crime of domestic abuse, aggravated assault, child endangerment against the person of Contrell Nicholas, which led to your arrest by the New Orleans Police Department on that same charge. On 10/8/2024, the New Orleans District Attorney's Office refused to prosecute that charge. But as far as the incident itself, do you plead guilty of having done that or innocent of having done that?
Sir, I plead not guilty, totally innocent, sir.
Okay. All right. Thank you, sir. Not guilty. Okay. Number 5, rule number 5 violation. You had in your possession or control a firearm when you committed that crime. The New Orleans Police Department said it according to their reports. And then on 10/8/2024, the New Orleans District Attorney's Office refused that charge. My question to you is, did you have a gun on that day in your possession?
No, sir, I did not. I'm not guilty on that. Those was allegations.
Okay, you're not guilty of that. So those are the 2 rule violations that you are charged with at this particular time. And so from there, I think it's time for us to hear what people that are going to be speaking for you. And the first one will be, let's go ahead and jump into Contrell Nichols and see what Contrell has to say. So Contrail, would you start, and the attorneys will speak last?
Sir, Miss Nicholas is here with us. We have a seat. ma'am.
Okay, and that's Contrail that we're looking at, Nichols?
Yes. Yes.
Okay, all right. Would you go ahead and tell us what you have to say? Now, please keep in mind, we have a lot of cases, and so you don't have an unlimited amount of time to speak. If you keep it to 3 minutes, we would appreciate it. Okay?
Do we get to ask her questions, or does she just give a soliloquy here?
Well, it's just a soliloquy is what we normally do. Now, if you want to ask her questions and let her answer, and that can be part of her time, and then you can close it out with a statement, that'd be fine too.
Okay.
However you want to present the case, we want to make it fair.
All right, Miss Nicholas, will you, do you remember the day that you called the police on Mr. Vita Munz?
Yes, I do.
Okay, and you remember the police coming out to see you?
Yes.
Okay, at that time, you told them that he pointed a gun at you on that day, is that
Yes, I
correct?
did.
Okay, was that a true statement?
No, it wasn't.
Okay, why did you tell the police that statement?
Because me and him had got into it. We had an altercation, so that's why.
Okay, you didn't, okay.
And I was mad.
You were mad, and you had had a long-standing relationship.
We
with
had
this-
been in a relationship for 32 years.
Okay,
Yes.
and then y'all broke up, is that
Yes.
correct?
Yes.
Okay, it's fair to say you were angry at him for that and among other things?
Yes.
Okay,
Yes.
so when the police came out, you said that he had attempted to harm you and had pointed a gun at you, is that
Yes,
correct?
yes. And I can ask one more thing?
Sure.
There wasn't no children there. It wasn't no children there.
That's right, that's right. They also said that there was child.
Games, yeah, no children wasn't there.
There was no children, there was no gun.
There was no gun. And after that incident, me and him hadn't seen each other since that year.
Okay, so there was no, anybody promised you anything or threatened
No,
you?
no.
Okay, you coming out here to tell the truth today?
Myself, yes.
Okay, and you went to the DA's office
Yes, I did.
and gave a statement to them, is
Yes,
that
I
correct?
did. Yes,
And you told them this and they dropped the charges based
Yes.
upon your representation?
yes. And I also saw his PO,
His parole
his
officer,
parole officer, and I wrote a statement for him.
and you, in that statement, you said the same things you're
I
saying.
said
here
the same thing I said today.
Okay, and that is that
He didn't have a gun. It was his phone.
it was his phone, not a gun?
Yes.
Okay. Is there anything else you'd like to tell this committee?
No, he's not a bad person. He's a hard-working person. It's just after that incident, me and him we never got together again. We never tell each other. He tell me nothing. I don't come around him. He don't come around me.
I understand. Okay. All right, well, I think that's all we have right now for you, ma'am.
Mr. Responding,
Yes, sir.
would you tell us which one, are you Michael or Joseph that's doing the questioning?
I'm Joseph that was doing that questioning. And we're gonna have, I don't know if he's on the screen right now, Mr. Valentino. Michael, is that
Okay.
you? You'd be on
Mike
next.
Valentino. Yes, sir. Okay, and you want him to speak too. Mr. Valentino, it's your turn.
Okay,
Thank you. My name is Michael Valentino. I'm in New Orleans, and we own several hospitality companies. We had just hired Mr. Mons to be a key member of our maintenance team, and we're sorry to lose him to this arrest several months ago. I've known Mr. Mons for a little, quite a long time, and we decided to hire him to be a key member of our maintenance team. And I'm just testifying today that we would like him to return and have a job waiting for him in our company as a key member of our maintenance team if he is released.
thank you. And obviously, I always ask this question, Mr. Valentino. Nobody's promised you anything, not that we could, but nobody's promised you anything or threatened anything. You coming out, he come to testify here of your own volition. Is that correct?
That's correct.
Okay. Okay, is that all you have, Mr. Valentino?
Yes, sir.
Okay, and just for full disclosure, Mr. Valentino and I have known each other for quite some time. And anyway, just want people to know that, we have not talked about this case, and it was a surprise. So anyway, let's see, we'll go to a questioning now. It's, well, unless we want to, let's see, we've had Contrell, Michael, the attorneys, would y'all like to have a closing statement now before we ask a few questions ourselves?
Yes,
Yes.
go ahead.
Okay, go ahead.
Well, as you know, the case was refused by the DA's office on October the 8th, 2024. This Mr. Muntz, once he found out that he had a arrest warrant out for him, he turned himself in on it. He went in and said, y'all, there's a warrant for me. What do I need to do here? I'm here. So he did that. The extent of the evidence on the underlying charge was the statement by Miss Nicholas, which she later said was not true. The initial statement, she said that to the district attorney's office. She said that to the parole officer, and she put it in writing. There was no other evidence whatsoever that this occurred, because it did not occur. And Mr. Muntz is totally innocent of this charge, and the DA recognized that. And I think that Mr. Muntz has become an upstanding citizen in society and has been working for Mr. Valentino and would like to continue to work for Mr. Valentino. Mr. Valentino would like Mr. Muntz to continue to work for him.
Okay. All right. Thank you, sir. And Mr. Do we have anything else to say from either one of the attorneys that you'd like to close it with?
No, sir. The lady is here, the Miss Nicholas, if you wanted to question her, she's still in our office, just so you know.
Okay. Okay, we do have some questions for her. The way that we do this, we all study the cases, and we've had this information for quite some time. We've all studied them, but then one of us leads the question, and then the rest of us can follow on that. This particular case, Ms. Stapleton has, Carolyn Stapleton to my left. Ms. Stapleton, would you lead the question, please?
Yes, sir. Listen, I watched the video where you accused this man of
Excuse me, this question for Miss Nicholas?
Yes, I'm sorry.
Turn the camera on to her, I apologize.
Yeah, Ms. Nicholas. I watched the video where the accusation was made, and you also had a friend there that backed up your statement that he had cut your brake lines, and that the reason he had your vehicle was because he was supposed to be fixing your vehicle. That led to the argument at the door where you cursed him, and then he, as you said, pulled a gun on you and said that he would shoot you. Your words, you know, I'll shoot you. So today,
shoot me.
You said that on video. Oh, you said it on video. They had body camera on for all of this, just so you know. I mean, when the police arrive, they have their body camera on for these types of situations. So that he's gone into his waistband and pulled out a gun. And so in today, you're saying no, and it looked like Gwen's law was enacted, so there couldn't be a bond on him. And so which, you said one thing then, and you're saying another thing now, why would you lie on me?
I was mad, and when you mad and a heated argument, you say anything. But like I said, he had a phone. He did not pull out a gun.
Yeah, you didn't know that he was going to suffer severe consequences with that lie.
No, I didn't know.
Yeah, that's the problem with stuff like this. You know, somebody really suffers consequences, and a lot of times it's still the truth. And, so that's the only question I had for you. And then back to, Mr. Mons. I want to ask you a question, please. I noticed that when I was reading the report, the agent made comment for the preliminary hearing that you were very upset that you had wanted to attend your child's graduation. Which has that already come and gone, that you were very distraught over that?
Ma'am, that's why this whole argument was a part of the graduation. The graduation was May the 18th. This incident happened around after the graduation, ma'am. This incident is almost 15, 16 months ago.
Yeah. So, all right, so you did, all right, so I did note that, that it was put in here that you were very distraught about missing your child's graduation, and that was part of the reasons why there was an argument and everything. So I don't have any further questions.
I got a question. I'm looking at your parole file, and it says that on 12/27/2018, you were arrested for domestic abuse, battery, and simple assault. And you got a reprimand from the parole board for that. The question is was that the victim back then, Miss Nicholas?
No, sir. Yeah, the girl come on my job, sir. I was at work when this took place. And they got the video from Pep Boys, which was next door, showing I did not hit her. She pulled the computer out of my hand. And that's when she came forward and dropped the charges.
So it was not Miss Nicholas.
Miss
Positively not Miss Nicholas.
No, it was not Miss Nicholas. No, it was not Miss Nicholas.
Okay. That's all the questions I had.
Okay, I don't have any questions. Mr. Open, you ready to vote?
Yes, I'm ready to vote.
Okay.
Okay, today, based upon, I know that the sheet says probable cause, but everything else has been said. My vote is going to be not to revoke.
Okay.
All right. Yeah. I'm gonna vote to not revoke, but add a special condition that you complete domestic violence training.
Okay. All right, and I concur not to revoke, and I wish you well. You're gonna be a free man after today. And so, you use it wisely. And I always like to say that you're supposed to, when you're on parole, avoid the appearance of impropriety. Stay away from women like this that lie on you, okay? All right, that's it. That concludes this hearing. Thank y'all for all appearing, and time is 10:36.
Thank you, gentlemen. All right. There you go.
Thank you.
So when you come up, you can I don't know if she knows.
Hello, Mr. Wright. How are you today?
Oh, my name is Sheldon, sir.
No, shoot.
What's his name?
Sean LaGarde, the one that we had
We
booked.
need Jonathan Wright.
Is anybody in the room with you there?
No, no, sir. You want me to call the deputy? Here they come right now.
I won't be.
Okay, somebody walking in behind you. Tell them we were looking for Jonathan Wright.
Yes, sir, I have him right next door. You want him next instead?
We want him first, please.
We need a second.
Yes, sir. How are you, Mr. Wright? Is your name Jonathan Wright?
Yes, sir.
Okay, do you have a piece of paper in front of you?
Yes, sir.
And that's information about this hearing, and you, did you want an attorney? Could you were eligible to have an attorney, but not one appointed for you. Did you want to hire an attorney or anything?
No, sir, I was, just gonna have, speak for myself.
Okay, and what is your DOC number?
723-088.
Okay, my name is Steve Prater. As you can see on the name tag, maybe, but I'm the chairman for today. On my left is Carolyn Stapleton. On my right is Danny Barrock. And we're here at headquarters in Baton Rouge, and we're here to decide if you should be revoked on your parole or not. There's a list of things, of rules that you can violate that get you revoked. And I think you know that probably well because you've dealt with that ever since you've been on parole. And you're accused of violating certain of these rules, 2, 3, 4, 9, 10, and 11. And so what I wanted to hear was what you say about those. 2 is absconding jurisdiction, that you went out, even out of the state. 3 has to do with you didn't provide your address. 4 is criminal activity. And that's because you had to be arrested because you absconded, and that was a crime. Number 9, you agree to visits at your residence. Number 10, you owe $945. And number 11, you didn't fight extradition. Now, you had a hearing on these and you pled guilty to all of them except the extradition. Is that correct?
Sir.
Say that again, sir?
Yes, sir.
Okay, that is correct then.
Yes.
Okay, so do you have a statement to tell us as to why you did all of that? Because
well, when I released, I was released, the immediate release, so I didn't have the proper chance to get address by me not being from the state. So when I did get out, the person that was gonna let me stay with them refused the offer. So when my financial support got sick and my mom got cancer, I had no where to turn to, and I was scared to tell my parole agent that I didn't want to go. So I was trying to do it myself. So I didn't have, the proper resources that I needed to get a proper address or identification or employment. So when my mom got sick, I just went back and helped her for a while. And on my way back to Louisiana, I was pulled over and arrested on a parole warrant. But the 90 days that I've been here now, I've talked to the case manager to help me get
into a program to get me housing and employment, so I would have the help now, but I didn't have the help then that I needed and didn't really ask, so I didn't give myself a chance to get any of the help from anyone because I didn't know who to turn to or get the help from. So now that I have got that through this 90 days I've been locked up here through the case manager, so I do have a little support group now to get me housing and employment now.
Okay, how long were you in jail?
I've been in jail 90 days. I was released from prison. I did 7 years, but I was supposed to do 6 flat, but they are briefing ARP, and they took good time that I didn't have, and they immediately released me. So when they did that, I didn't know that I needed an address or I had to come up with an address. So I ended up getting out and I had to try to put all these things together by myself, and I didn't know what to do.
Did you go through a reentry program?
Yes, but I didn't get no good time.
But you did one time, you went through and they should have made sure you had an ID and all that business, right?
I didn't have that at all. No, when they released me, all I had was the release paper from the prison. I didn't get no identification at all.
Did you understand that you had to go to the parole office?
Yeah, I went to the parole office. I saw the parole agent there, and the second visit I went, I saw my actual parole agent, and I was still trying to figure out how to get placement somewhere to live, because he said the next visit would be at the place that I'm living. So I was trying to figure out how to get me somewhere to stay without going to a shelter, and I couldn't get in the shelter because I didn't have identification at the time.
Okay. Why did you think you could go to Illinois?
I didn't think I could go to Illinois. My mom got sick, and that was my only support group, and I didn't want to sleep on the ground or be homeless, so I just went and helped my mom. And when I got there, talked it over with my mom, and she told me what to do. So I came on my way coming back to Louisiana. I was pulled over on the highway, and they said that I had a parole warrant.
Ms. Stapleton, you got any questions?
Okay, so you had a car, so you drove to Illinois from here? Is that what you did? Because you said by driving back.
Yeah, I was in my brother had let me use one of his cars to come back to Louisiana, and I ended up getting pulled over, and they said that I had a parole warrant, but I didn't know it at the time.
Louisiana, without any money, without any ID, how did you get from Louisiana to Illinois? Did someone send you?
On a train.
On the what, I'm sorry?
Train.
Train? You had the money for a train?
Yes, ma'am. My mom paid for a train ticket, and I was able to get on the train.
Okay, okay, I was wondering how you got there.
But now I do have the sources that I need to do everything right with the case manager here to help me get the proper things that I need to have an address and have employment now. So I have the help now to do those things that I need to do the first time.
Now, you said also that you went there because your mother was sick with cancer.
Yeah, she's still in the hospital now.
So you're not going to need to go back up there, but you're not going to ask for, to be able to go back up there because she's sick.
I talked to my parole agent supervisor, and she said that she will provide me with travel passes that I didn't know that I could get the first time. And if I needed to go up there and see her or help her with anything, she said that she will allow me a travel pass if I needed it. So I do know that now I can ask her or talk to her before just up and going and be.
This is your first time to be on parole?
Yes, ma'am.
Okay. All right. I have no further questions.
You have somebody that's gonna help you out financially right now?
Yes, sir. The first 72 across the street is willing to take me into their program and, give me housing and help me with employment. So I will talk to the case manager, the time that I've been spent here in the parish jail.
So if I was to order your release and put a condition that you pay the cost of extradition before your release, can you do that?
It depends on how much, because of my support group that's helping me financially is on a fixed income, but they do allow me, they do send me $100, $200 every, blue moon to help me with my financial background, to keep me with clothes or food, shoes, things like that.
All right. No more questions.
Okay, all right, I guess it's time to vote then. Okay, I'm pretty much a stickler that if you serve seven years in jail or whatever you serve, you know what following the rules means. And when you get out and your parole officer says, you got to stay in touch with me and let me know where you are, that means exactly that. And that is one of the simplest things to do, is to pick up the phone and say, parole officer, I am at such and such. I'm having a hard time. Help me out here. I got to go to Illinois to see my mom. Staying in touch with them so that we know that you're doing good. I'm not here to lecture you, but I'm here to vote. And I don't think you've learned how to follow the rules that everybody else has to follow. My vote is to revoke his parole.
I agree with Mr. Prater for the same reason. I mean, you did that pretty quick and easy, so something else comes up again.
Only one visit, but I kept in touch with her the whole time. I only missed one visit when my phone went off, and it was off for 2 months. And those are the 2 months that she couldn't get in contact with me. But I stayed in contact with her. I went to the office as she asked when she told me to come. I only missed one visit, and that was the time that my phone was off. But I stayed in contact with her at all times, and I told her everything that was going on with me. As even when she told me that my interstate compact was denied, I was still keeping in contact with her, letting her know what was going on.
Well, it says here, you last reported on 9/14/2023, and that attempts to contact have been unsuccessful, and attempts to visit the offender at his reported address of record was unsuccessful on 3/2024 and 5/2024. So I'm gonna vote to revoke.
And I'll concur with my colleague.
Okay, that'll conclude this hearing. As of today, your parole has been revoked. I'm sorry. I wish you well, and maybe it'll work out better the next time that you get to roll. You got to abide by the rules. Thank you. That's 10:55. End of that. Orleans Parish. Okay.
All right.
I thank y'all, man, for helping me.
Mr. Lagarde, is that you?
Yes, sir, it is.
Okay, would you tell me your full name and your DOC number, please?
My name is Sean Ray Lagarde, DOC number 490372.
Okay, thank you, sir. My name is Steve Prater. Okay, I'm the chairman, acting chairman today. To my left is Carolyn Stapleton. To my right is Danny Barrow. Okay, we'll be hearing your case today as far as whether to revoke your parole or not. I see that you have some folks here that are involved and are going to be speaking later. You have an attorney, Krishant Dania, if I'm probably saying that name wrong. And then you have a social worker from the New Orleans Public Defender's Office, Brian Lars, who will be speaking. Yolanda Cambris will be speaking. That's a sister, and Miranda Harris, who is your mother. They'll all be speaking by Zoom in just a few minutes, okay? But before we get into that, you got that piece of paper in front of you, correct? Okay, and that piece of paper you signed, it talks about your right to have an attorney. Of course, you have hired an attorney. So that's all that part about us appointing an attorney is moot. So, but it also tells you your rights, and you sign, that's your signature on that page, right?
Yes, sir.
Okay, all right. When we have one of these revocation hearings, what it is, we're trying to determine if you violated certain rules that you agreed to when you got out on revocation. And you understand that, right? Okay, you're accused of violating two separate rules. Okay, the rules that you're accused of violating are number 4 on the DLC sheet that you signed, and number 10. Number 4 says that you shall not be involved in any criminal activity. And you were charged with a domestic abuse battery on I think 6/12 of 2024. And then subsequently, the Orleans Parish District Attorney's Office null-prossed or dropped that charge. Okay, my question to you is, are you guilty or not guilty of that domestic abuse charge?
I'm not guilty of it.
Okay, all right, thank you, sir. The second one is Rule 10. That says you have failed to make a payment towards your parole supervision since 5/1 of 2024, and you are currently $830 in arrears. Okay, and are you guilty or not guilty of that? And do you have a statement about it?
I'm guilty with a statement.
Okay, what is your statement?
The statement is, when I didn't know I was that far behind, but I made payments. I stayed dedicated to payments, but I did get behind on somewhere. I couldn't afford to pay for it. And that comes with how much I make bi-weekly. And also at the same time, me paying 100% of the bills towards taking care of my family. We don't get food stamps or anything.
Yes, sir. And you've been in jail since for a good bit of that time also, correct?
Yeah, from 6/12 until today.
Okay. All right. Well, we're going to have some folks. Go ahead, sir.
I had kept my parole officers, both of them. I kept both of them informed on when I couldn't make payments. And they was like, that's okay, just try to catch up next month, try to catch up next month. So I did try to stay up on my payments, and he knows that even when I went out on short-term disability, right before the month of 6/1, and I let him know then, I said, I can't pay because I'm not working. He was like, don't worry about that. You can't pay if you don't have it.
Okay, that makes sense. That makes sense. Well, we're going to hear from some folks now. And the way that we normally do this is we hear from 3 people, plus we will hear from your attorney. So that's a total of 4 that can talk for you. And these 3 folks, we want them to know that that's fine to talk for you, but that we have to limit the time because we'll be here all day, as many cases as we have. So if the mom and the sister and the social worker from the New Orleans Public Defender's Office, if the 3 of you all would try to limit your remarks to about 3 minutes each, which is really a long time when you consider it. And then we will end up with the attorney Dania, if I'm saying that right, I would be surprised. But anyway, that's who we'll end up with to give the close.
You got it right.
Okay. All right. So let's go ahead and get started. Miss Miranda Harris, your mom, Mr. Gordon. Miss Harris, would you go ahead and start us off, please?
I did not.
It's Miranda Harris.
My name is Miranda Harris. And Sean is my son.
Okay.
Sean did not hit that girl. He did not do nothing to her. She hit him.
Okay.
But Sean did not hit her.
Okay. Did you witness this?
Yes, I did.
Okay. All right. Does the board have any questions of this particular witness?
Yes, ma'am. I want to ask you, because we do have a body cam of you speaking to the officer, and when the officer asked you if you saw anything, you told him no, and you said that you heard the argument going on. That's what you said. That was on body cam.
I did see her hitting him. And I was trying to stop her from hitting him.
You didn't say anything about it when asked. Just saying. Okay, I don't have any further questions.
Okay. Okay, no more questions. Thank you for appearing and thank you for your statement. Now the sister Yolanda Cambris. Is Yolanda there?
Hello, yes, I'm available. This is his sister Yolanda Cambrise.
Okay, would you tell us what's on your mind, please?
So far, since my brother has been released from the first time he was incarcerated, he's been doing very well and getting his life together. He's been working, he got his family back together, and he's been on a stable job as well. So I don't know how the situation came about, but I can tell you that he's been very adamant about living an upright life and doing what he needs to do in regards to his parole officer, in regards to his job. I actually spoke to the people he works for, and they have spoke very highly of Sean Ray. Also, he is able to get his job back with the company that he was working with as well. The people who he worked for, his co-workers, all these people have spoke very highly of my brother and don't even know how he got put into the situation that he's currently in right now, which I don't even know how he got into the situation, knowing that he's been trying to keep his family together. So that's what I do want to say. His job has spoke very highly of him as well.
Okay, well, we thank you for that. Appreciate your input. All right, Brian Lars. Is Mr. Lars here?
Yes. Good morning, board members. My name is Brian Lars. I'm a social worker with the Orleans Public Defender's Office. What I would like for the board to consider is that, I know you have a copy of my release plan. I connected him to some resources that I think that'll be very helpful to Sean. But what I would like for the board to consider is that I've had several opportunities to meet with Sean, and we discussed this incident, and we talk about how to respond to certain things. And I think that he'll express to you that, he could have responded to the situation in a different manner. I don't believe Sean actually hit his ex-wife or girlfriend. I don't think that happened, but it's about just, learning coping skills. And sometimes, I work with a lot of individuals like this that just don't have the coping skills. So I connected him with some resources like CADA Prevention and Recovery, First 72, to help him to build these coping skills. Sean has 4 kids. And, when I think about me, and me raising my kids, and I've had disagreements with my wife, but it's about the response. It's about how we respond to situations. You know what I'm saying? And he just need to, identify that he just need some additional support. He's 2 things that are very important that I did not add on his reentry plan. And Ms. Cambrise talked about it. Sean can go back to HRI Properties, where he worked in the maintenance department for over 2 years. And he can stay with Ms. Cambrise. She can confirm that as well. But I think that, Sean is a good person. He realized and he expressed remorse for how he handled the situation. And he can talk about some of those things when he has the opportunity to talk. But we here for him. We have a whole team here at the Orleans Public Defender's Office. We have other social workers, client advocates. I do so many cases like this, and we've witnessed a whole lot of success. We're working with CADA and First 72. So it's our hope that you will give Sean another chance to get to his family. He got 4 kids, and he's the sole provider for those kids, and they need him right now. Thank you.
Okay. Thank you, sir. Appreciate your input. Now we'll close it out as far as support goes with Krishant Dania. The attorney.
Yes. Thank you so much. Thank you so much, members of the board. My name is Krishant Dania. I've had the privilege of being Mr. Lagarde's attorney since the day of his arrest. I won't go over too much of what's already been said, but I do want to discuss just my impressions with Sean. We're very busy in Orleans Parish, and I've met a whole lot of people, a whole lot of folks in similar situations. The thing that sticks out to me about Sean is, whenever we went over the case together, Sean and I both agreed that I don't believe that he did anything. And when we took it to trial, the morning of trial, we were ready to exonerate Mr. Lagarde. The district attorney elected the morning of trial to no pros the case, so we did not get to secure the not guilty verdict. But I remember speaking with Sean afterwards and the conversations that we had before. The conversations where Sean talked about how during his first stint of incarceration, he found his faith and he was resolved to become a better man than the man he was before he went in there. Sean remained optimistic. He remained optimistic that despite this shortcoming, he will leave this experience a man who will not land himself even in the same situation again. Because despite the fact that Mr. Lagarde did not commit this crime, he does acknowledge that he was in the wrong situation and he could have de-escalated. Now, Mr. Lagarde and I have worked with Sean to develop this release or reentry plan that would involve him going to CADA and the first 72. And I want to reiterate the support that Mr. Lagarde is going to have for my office. I've grown to care about Sean. I will be a resource for him as well. My office cares about Sean. We've all gotten to know the person he is. I know that this meeting can't ever show the depths of like a person, but I do hope that the board does come away from our conversation with the knowledge that Mr. Lagarde is somebody who deserves a second chance. And Mr. Lagarde is somebody who I do believe has and will contribute to his community at large. So I just want to respectfully urge this board to allow Sean the opportunity to return to his family and to live a better life.
Okay, thank you, sir. Appreciate your representation and your words. We'll take them to heart. Ms. Stapleton, I believe this is yours, and I think it's your turn to start asking any questions you might have.
Yeah, I'm going to start off with something very important that I couldn't find for Mr. Lagarde. I found that there was a protective order issued on 7/17/24. I could not find the protective order in my paperwork with the effective date of when it was going to end. Is that protective order still in effect as to you going back to your family who needs you so much? Because it's brought on by the state, not by the victim.
So, if I may, I believe that the protective order had expired whenever Mr. Lagarde's case was closed.
Okay, now let me ask you this. Y'all said that the DA did a null pros, but you didn't say that the victim dropped the charges. Did the victim drop the charges? Because I didn't see that either.
I have no knowledge. I have no knowledge on why the district attorney decided to no pros the case. We were ready for trial, and then the district attorney, the morning of trial, said that they no longer wish to pursue the case.
Okay. All right. Well, we don't have in here that she recanted, which speaks to the seriousness of it, really. And we saw everything on body cam, which helps us a lot, I have to tell you. So when the police arrived and spoke to the victim, she was crying. She cried throughout the entire interview, by the way. And then they came up and they talked to you. And the main thing you complained about was your stomach, that you need to go to the hospital for your stomach. The police said in their report they did not observe any laceration on your head or any place on your body where you were injured by her. But that all you complained about was your stomach and you need to go to the hospital, which they took you to the hospital. So I don't see where he was injured by the victim, but the victim, on the other hand, she did show her upper lip, and you can see clearly that it was cut across the front. And she said that's when he slapped her across the face. And you said that that was because you poked her in the lip. So you admitted to that. You just didn't admit to slapping her and just poking somebody in the lip. I don't care what you did, really and truly. She had a busted lip, and we could see it on video. The second thing is that they asked her some very important domestic violence questions that I'm seeing more and more law enforcement really turn into that, and that makes me very happy to see this. And they asked, did she think that you would kill her? And she said she didn't know, but that you had a very bad temper, and that you threatened the children, and that you threatened her, and that she's scared of you. You know, but that's in the police report, that you have a very bad temper. And then it's, are the threats and assault on her getting better or worse, or have they changed? And she says they're getting worse. That's when she continued to cry throughout the video. And it says, when have you been the most frightened of him? And she said, today. And then they asked about firearms. She said that you do have a firearm in the house, that you do have a gun in the house. And they asked her what kind it was. She didn't know that it was some kind of black gun. Do you have a gun in the house?
I've never been arrested for a gun. I've never owned a gun. I've never owned a gun ever in my life. You know, I never have a charge for going to jail for a gun or nothing. You know, for her to say that, even though I know y'all don't have a 911 call tape. On the 911 call tape, she said that I had a brown gun. And I even asked, when I first met Mr. Dane, I had told him subpoena, and I even got it right here. I told him everything to subpoena. I said, subpoena the 911 call tape, subpoena the body cam footage, subpoena everything, subpoena even my house camera footage to show what had actually happened. You know what I'm saying? And here, you know, I never owned a gun, man.
Okay, so those are the questions that I had for you. That's it for me.
I see in the reports that you admitted that you hit her after she hit you in the head. And now you're saying you're totally innocent.
All right, ladies and gentlemen, jury, the bailiff has passed me a note that says, what if we can't agree on a verdict? Question mark, anyway. At this time, I'm going to ask that this note be made a part of the file. If somebody please take care of getting that done anyway. I'm going to read you the court's instructions in this regard. I know that it's possible for honest men and women to have honest difference of opinion about the facts of the case. But if it is possible to reconcile your differences of opinion and decide this case, then you should do so. Accordingly, I remind you that the court originally instructed you that the verdict of the jury must represent the considered judgment of each juror. It is your duty as juror to consult with one another and to deliberate in view of reaching an agreement. If you can do so without violence to your individual judgment, each of you must decide the case for yourself, but only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberation, do not hesitate to re-examine your own views and change your opinion if you're convinced that it is erroneous. We do not surrender your honest convictions as to waive or affect the evidence solely because the opinion of your fellow juror or for the mere purposes of returning the verdict. So please continue your deliberation. I would ask that this be made a copy and that this written instruction be sent back to the jury room, okay? I want to ask y'all to continue. I know you're giving it your best, but I ask you to continue your instruction. If you'll get a copy of it and let me have my original back and send that copy into the jury room. All right. I'm gonna get this instruction in writing back to the jury. Bring me my copy back, and court will be in recess until we have further word from the jury. All right, here's everybody's present. We have a note from the jury that says, "We feel confident we are unable to reach a unanimous decision." Would that note be made a part of the court file and filed in the court file? The court's intention this time is to bring the jury back in and make sure I tell them, don't tell me how you're divided as far as towards guilty or innocent or which particular charge, that there's several charges they could pick from, about which charge you're talking about or which way one side is leaning one way or the other, but ask them if they can to give me a numerical division to the best they can. Depending on what that number is, may have some bearing on the court's decisions about continuing deliberations or not. If you would show the jury. All right, ladies and gentlemen of the jury, I have received your note that says we feel confident we are unable to reach a unanimous decision. I would like, have you got somebody that y'all think can be your spokesman? But I'll just address the question to the group and go from there. But I want you to make it clear before I ask you the following question. Do not tell me whether you're more votes for guilty or not guilty. Don't tell me which count that you're considering. There are several options. There was capital murder, first degree murder, capital murder, first degree murder, second degree murder, negligent manslaughter, and not guilty. Don't tell me which one your vote's on. Don't tell me which side is winning or losing, for lack of a better word. But can someone tell me, is there a particular numerical divide? What's the score, for lack of a better word, anyway? Can you tell me that? 11-1. Score being 11-1, I'm going to send you back. I understand you've got your difficulty, but I'm going to send you back to review the court's initial instructions I gave you earlier to examine your own thoughts and beliefs and continue your deliberations anyway. Okay? Thank you. Court being recessed.